Pardon, hosted since 2017, praying for bail.
Hearing this is appellant is in custody 1/11/2014. In the meantime, I filed an IA on the ground of health issue of the appellant. Left portion of the appellant was totally paralyzed. So,
Publication note 13/139/2024. This matter is covered to Mile's judgment dated 2nd July 2025 Mile's. Passed in WPC number 21713 of 2024. This matter was received before Mile on 9th of July. I saw a copy on Mr. DSG. And this matter adjourned to be listed. We commencing 14th Mile. This matter comes.
The petitioner is in custody since last 10 years.
Supplemental list. Supplemental list. Item number 1.
Is to be decided in the court level. Cannot be so.
What is challenged here?
Challenge the recruitment process is not a challenge.
Mr. Das, when counsel appearing for the petition, submits that in view of the nature of dispute involved in the case, matter cannot be settled in the special mediation drive mediation for the nation. And the matter may be listed before the regular thing.
Yes, no.
So yes or no. So the wait for yes, next.
Item 2.
The matter is you.
My lord, I am appearing through BC.
Yes.
The opposite party have been directed to give their opinion today.
My lord, it will not refer to the mediation because the main contesting party is state government. On the basis, I'm just 1 minute, I'm clarifying. He resigned from the state. Resignation has not been accepted. He joined another organization.
Yes.
Then he is coming to the AIMS. On the basis of that resignation, he has managed to get a resignation certificate for another institution without, even though his basic resignation from the state was not accepted. The state communicated the AIMS. AIMS said that because your resignation is not accepted in the state, you will not allowed to join here, continuing here. On that basis, challenge the petition. The sub judice knowledge, it is required hearing.
My lord, without giving any opportunity, they have done it.
It's all right. We are not hearing on.
We adjudicated in, we are just deciding whether the matter be referred to the mediation or not. Okay, so in this matter, we have stated that it is to be heard by the regular bench, right? Okay. Yes.
Item 3.
May I please? Madam, in this case, I have challenged the order of dismissal partial on tribunal under Annex 6 man. This is a case of promotion from junior technical officer to assistant technical officer and issue involve reservation in promotion matter. May I please this matter be heard?
Regular bench.
Item 4.
What is the prayer made? (16/8, 2016) order. That is annexure 1. What was the prayer?
they are the reserve category candidate. They are claiming that you are getting the promotion as well. They are hearing list.
Acha, let us do. The mention is made on behalf of Mrs. Madhumita Panda, that the brief has already been transferred. Stop. None appears for the petition. It wishes to intimate the petitioner about that for engaging some other counsel to conduct the case, and it will also be intimated that a legal panel counsel can also be engaged to argue the case on his behalf. So, matter be listed after 4 weeks for the name of Mrs. Madhumita Panda shall not be reflected in clause list. Stop. Looking at the prayer made and the submission of the land council for the state that the matter cannot be settled so and so, put up before the regular bench after 4 weeks. No? Yes.
Item 5.
And this is regarding antedate seniority and promotion. And this may be because hard for this bench might also. In the other bench also this has been decided. So it will be hard here, my lord, and date may be fixed because
Regular bench.
2017 date may be fixed.
Next.
Item 6.
What is this matter, Mr. Nayak?
No, that is six, that is the earlier non-apparent dismissage. That is CMPL file person.
No, CM appeared, perhaps
On
the
the-
case has been restored. That is how it has come. Otherwise, it would have come with that CM appeared. Na kaun ek hai ji?
CMPL has to be 925/19. Should I be disposed of the coach?
Last order was passed
No,
on.
it is already recalled. The dismissal order is recalled and consequent petition of restored to its position, original form.
So that is nothing. Now, what is the prayer here?
Antedating the promotion.
Order of this SAT, the challenge, on the ground of this SAT has rejected his application on the ground of delay. That
Regular
was.
bench. But you mentioned that none appears for the petitioner. So,
Item 7.
It is a regular method.
This is item 7 is a reversal matter. We are challenging the tribunal's order, STL tribunal's order. And there is 2 connected matters. Another matter is by fraud, they have taken order, that was my allegation.
so it is to be set, it cannot be settled in the mediation, regular bench. All right.
Item 8.
Mr. Pari, it is your matter.
Yes, man. Yes. Sorry, I will not on.
Tell us whether the matter can be referred or not. It is to be heard by. What is the prayer? Item number 8.
It may be referred to the meditation.
I have objection.
Transfer matter, we will not settle.
Transfer matter, my lord, I own before the Law and Tribunal. They have filed this writ petition and that has been stayed. Now, my lord, that this issue cannot be settled by the Law and.
What is the issue?
My lord, issue that
Transfer
one
matter.
post, 2 claimants are there. So far as this, my learned friend is concerned, he is representing one. Then adhere to that application, she filed claiming he is posting in another place. That way was pending before the tribunal. When another post came up, I made the application that I may be observed there. Then she also made the application to be observed at second place. Both the cases were heard by the Law and Tribunal, and Law and Tribunal decided that she will be observed there, I will be observed here.
Yes.
Now the state is telling.
It will go to regular bench.
Yes, ma'am.
Yes. Next.
Item 9.
You are with, yes, you are connected matters.
9 was it. When it is a case of against the order of tribunal, and the selection of judiciary that put in the postal department is also regular things are also.
Next.
Item 10. We are going to take it out and we done the third one. And we are going to take it out and we done the third one.
I request my land
Just say
sister
whether it
to,
is to go to the, yes, Mr. Pari,
my lord,
item number 10.
yes, I request my sister to serve a copy. I'll make it directly return to him because the file is not with us. So I don't know.
It's in promotion, matter, okay.
The promotion matter. Then promotion matter is come to the regular branch, my lord.
Okay, Mr. Pari and the Solicitor General submits that he is not having the copy of the writ petition. Let the land counsel for the petitioner serve the copy of the writ petition on the land counsel for the Union of India. But Mr. Pari, in this case, counter affidavit and rejoinder have also been filed. Are you having the copy of those?
Then my lord will take a from pen drive if lordship permit.
Submit that one.
Miss Separias is appearing with me. She will collect the from
It
pen.
appears that counter affidavit and rejoinder to counter affidavit has already been filed. Let the land counsel for the Union of India be permitted to take the reading in the pen drive. Okay. So it is further stated that the matter cannot be so answered. It's a regular bench. Okay. Yeah.
I'll provide the list, my lord, according to the name, maybe.
Please collect the in the pen drive. Please collect it because it is available now with us. So give the 8 and collect it today
I
itself.
request my
Okay?
sister to go and collect today. Itself.
Okay.
Item 11.
Sir, item number 11, 12 and 13, all these three matters arise out of a common judgment passed by the tribunal and the matter needs hearing.
Regular bench, regular bench, regular bench. Yes. 11, 12, 13. Yes.
Item 14.
Item 14 may the petitioner challenge the order of the land tribunal.
14, 12. Just one. Yes.
Here the petitioner the order of the land tribunal, my lord. The petitioner is seeking for promotion, my lord. Readings are already completed.
Regular bench.
Item 15.
Item 15, my lord, the question of appointment is
Why is not sending the other matters like assignment to do खाली से subject matter would have proposed. It's a number of where is that list? Assignment list. It ରହିବା କଥା ଟିକେ ନାହିଁ.
Item 15.
Item 15, question of appointment is in law.
It will go for regular bench and let's may allow us to take a pen drive.
Item 16.
15, my lord, I am for the opposite party. The order of punishment has been passed by Learned Tribunal.
And it will go to the regular bench.
Or B. Yes, Mr. R. Item 17.
Item 17.
What is the prayer here?
17, my lord, this applicant, the petitioner challenged, my lord, the order of dismissal passed by the Learned Tribunal as well as, my lord, the order passed by the respondent ordering for recovery of about, my lord, penal damage rate of about 15 more than 15 lakhs. The petitioner is a postal assistant, clerical career employment. The quarter allotment has never been cancelled, man. They cancel only after this person has opposed on the court, man. Then only they cancel it on that retrospectively. And my lord, the
Quarter
yes, my lord,
usual
on the
rent.
entire period.
We
my
can
lord.
send it to mediation.
Yes, regular hearing the also counter hearing.
Why regular hearing? It's my money matter.
Counter hearing.
Let us see the money matter, let us go to the mediation. Yes, Nati.
Item 18.
Mr. Pari, it is your matter.
Yes, sir.
Ajay Kumar Roy. Ajay Kumar Roy.
It will also go to the regular bench, my lord. So this matter,
Appearing minors to the
Ajay, right?
Achha.
Ajay is there, yes.
Mr. Ajay Kumar Roy, Senior Panel Counsel, Government of India, has filed the memorandum of appearance, which is taken on record. So, Mr. Pari, we are deleting the name of Mr. Prabhu Prasanna Behera.
Yes, my lord.
We are seeking Mr. Pari.
So bad.
Mr. Pari, the name of Mr. Prabhu Prasanna Behera shall be deleted now from the cause list.
Yes.
Okay.
Yes, he is
The
joining
name
the
of, the name of Mr. Prabhu Prasanna Behera, CGC shall not be reflected in the cause list, and in its place, the name of Mr. Ajay Kumar Roy we mentioned, and it has to go to the regular bench.
Regular bench.
regular.
Item 19.
Agenda is ready, we'll file in the
But this is regarding the pay fixation and interest
recovery from the return.
recovery. Then we can send it. Recovery.
Recovery, my lord, already refunded as per the direction of the tribunal.
No,
So
let's
therefore
just
we are
let
sending
it go to the mediation.
My lord, the recovery part already we have payment has been made. Exclude the fixation of pay, my lord, that has been challenged.
Just check it out.
Check it out. If it is not there, it is.
My lord.
Yes. Regular bench.
Item 22.
Support not type twist चल रहे हैं
22.
In this matter, your lordship kindly see the order dated 12/3/2024. Here, my lord, I paid, my lord, the matter can be remanded because, my lord, the
We are just say whether it is to be heard by a regular bench or to be referred to the mediation. That much we are just doing at present.
Can it be settled in mediation?
the paragraph 5 of the order.
Paragraph 5 of the order.
Because the point is, my lord, he has cited the decisions, but whether those are applicable to this case or not, that is not
Ajay,
mentioned.
it's a recovery of the amount of.
So your lordship wanted to get instruction whether it can be remanded. Mr. Padi, as my lord, your lordship paragraph.
What do you say, Mr. Pari? The order has been passed for punishment of recovery of 7,31,000. So it can be, let it go to the mediation and.
It may be referred to regular.
Okay, mediation. Next.
Item 23.
Already copies are served on me.
No, it's all right.
That is noting over there. Copy not served.
It will key the item number. Mr. Rahul and counsel appearing for the petitioner submits that extra copies of the
4 extra copies.
4 extra copies of the writ petition have already been served on the land council for the Union of India. Yes. Yes, item 23.
Item 23, the opposite party not the copy of counsel.
It will be decided here, my lord, on merit.
Merit.
Regular.
But you saw the.
I'm just solving.
Have you not filed the appearance memo?
But I'm filing. I'm just filing.
Give it. So and so files the appearance memo. Which is taken on record in proper format you filed.
Yes, I'm on the course of day, I'm filing.
If other submits that the copy of the counter affidavit which has been filed by opposite party number 3 will be handed over to the London Council for the petitioner in course of the day like those.
My lord.
In course of the day. And what about Whether we'll refer or it will be
On the bench, regular bench.
regular bench.
I'm already solved the problem.
Ajay, copy solved in court.
Item 24.
24 by that method relating to appointment.
Regular bench,
Item 25.
along with all the connected matters, huh? Yeah.
The Lordship, in item number 25, the order of the Central Administrative Tribunal is under challenge. The tribunal had directed to give compassionate appointment to the opposite party on the basis of the rules prevailing on the date of application.
So let it go to the
Let it go, let's
mediation,
see.
let us see. Mediation government.
Item 26.
This is may please your lordship, minor matter can be referred to the mediation.
Okay, mediation.
Item 27.
27, your lordship's order dated 21/10/24. In the tribunal, the opposite party has won the case with regard to the leave salary and gratuity. And when that has not been completed, a contempt is pending. Now they have challenged the order of the London Tribunal, Central Administrative Tribunal, and you will also kind of glance the order dated 21/10/24. They have stated that they have not challenged the order of the tribunal. But you will also, when a query is made to the London Council for the Union of India by us as to whether gratuity amount has been calculated and paid to the opposite party, he seeks some time to obtain instruction.
So let it go to the,
No, you will also kindly, the opposite party earlier in the railway department, rendering 12 years of service.
Can it be settled or not?
Now he is in the state government. So that leave salary as well as gratuity, that has to be.
खाली देखियो गते इटा mediation को जीवो.
Mediation, it should be hard by your lordship. Already Honorable High Court Delhi decision is there now.
This is gratuity amount is to be calculated and paid to the opposite party.
Yes.
For this, it cannot be go to mediation. What are you telling?
And leave salary also. The
Why not let
what
take
they
it?
have the challenge the order that contempt is pending before the long tribunal.
All right, everything will be settled.
Mediation. Yes,
But they have filed. I am the opposite party. The Union of India.
All right,
We are seeing the nature of dispute. That's all. And yes, next.
Item 28.
Expeditious disposal of.
Here for registration of sale certificate is not required. We can use 17 to the Registration Act and so law laid down by the Honorable Court and administrative. Only to refer the registry of sub-registration.
No, his prayer is for expeditious disposal of
That is it.
miscellaneous application DY number.
Auction purchaser. Sale certificate issued by the central bank. Thereafter,
No, we have what order you are passing that he is to move an application there and he will pass necessary order. This much we can pass the order.
already this Honorable High Court.
This petition has been filed by the petitioner so and so with a prayer for a direction to this so and so for expeditious disposal. In view of the limited nature of the grievance, it is open to the petitioner to file appropriate application before the DRT for expeditious disposal. And in such event, the
DRT. Sale certificate issued if the petitioner by the bank.
This is pending expeditious disposal of MA DY kaha pakre pending achi jeta.
Sub-registrar Tahsildar. Sale certificate issue it has to be recorded in the record book of the sub.
Annexure 2 is pending before the debt recovery tribunal lekha hai.
Prayer may kind of class.
No, just see Annexure 2. It's pending there. DY 777.
The direction is to be, the petition has been filed before the DRT.
It's pending.
DRT is just to dispose of the matter. That's all he wants. What order he will pass, it is up to him. But
prayer may kind of class.
Yes, prayer only. Just see the prayer. Prayer, it says, are you holding the same file or something else?
7318 of 2020. 28.
7318 of 2025.
Yes.
You come to the annexure 2. This is the petition which is pending before the DRT cut up. And he wants just disposal of this MA. So why will ask the sub-register? It is pending before the DRT.
Pending since
And on prayer I am submitting.
Prayer we are not, what is order to be passed, that it depends upon the DRT. He just wants that expeditious disposal of that MA. Look on so and so and move an application for expeditious disposal. And it is expected that council will deal with the same in accordance with law. It is made clear that we have not expressed any opinion on the merits of this one. So, yes, disposed of this.
Item 29.
29 regular, it cannot be possible for.
Because here the mortgagor's property has been sold, but the mortgagor is also a guarantor. So the entire, unless the entire payment is made.
But the bank is faulting this.
The
Therefore,
bank
it can be.
So only because the.
who are you? You are the guarantor.
Mortgagor is the guarantor. So unless the entire amount is paid, so even if the property is sold, then there are.
I am only
We are not hearing anything. We are just seeking for your.
It may become a regular bench.
Regular.
So Mr. Nandi also says that. So regular bench. Yes, next.
It can be because they are twice ordered by the High Court. It has not been resolved.
All right, next.
Item 30.
Yes, Mr. Roy. What is the prayer here? Electricity bill correction by এটা যাও mediation yes mediation huh?
Item 31.
31, Your Lordship, I may pray because Madam Ratha has been admitted to hospital. I pray for 2 weeks' time that the matter be listed.
Now.
Otherwise, they are suspecting typhoid.
Last time it was told
That is
that
the only reason. I've
AG will conduct the case and
even AG also not there today. Mr. Mahanti is assistant.
He has instructed since this, he has been appointed by the full court.
Made a submission. We have noted down that the Learned Advocate General is to place the matter, that the submission is to, has been also mentioned in order number 2, that Mrs. Pami Rathal and a senior advocate submits that Learned Advocate General is to address the court on behalf of the petitioner. That is said in appearing before us. That is how.
Your petition, you have to decide who is going to argue.
See, second case, where I am appealing, they have filed an application for amendment. I have no objection, let's allow that application. Only to consider the application, let them serve it.
They have not served a copy last time you are directed. In spite of that, no served.
What is the, just a minute, Mr. What is the instruction you have received from the Learned Advocate?
Learned Advocate General is that if they civilly initiate the matter, then if required, then Learned Advocate General will take it. Because he is in legs because of some part of the matter.
No, we are not telling. We just want to know because of the statement which has been made by Mrs. Ratha in open court. We have also recorded. She said that yes, AG is to address. Now she has some personal difficulty. It's all right, but at least tell us that when we'll place this case for in the list and wish to argue the matter. All these things. And another application has been filed for amendment. They have no objection, so that is to be allowed. Eta likhi diyantu. First matter lekhantu. A mention is made on behalf of Mrs. First Order Tanam, Mrs. Pami Ratha, and senior advocate, that she is not well, and it is to be taken up some other day. Stop. List this matter. Date tar chhad diyuntu. Tapre dutiya ta asantu. IN number 280 of 2025. There is an application for amendment of the review petition. The Learned Counsel for the opposite party Mr. Rautray, land senior advocate appearing for the opposite party, submits that he has no objection for the prayer made in the interim application. In view of such submission, the prayer for amendment of the review petition allowed. So what was the nature of prayer okay, so you filed a amendment, amended the consolidated review petition to be filed. You file it within a week and serve a copy on the Learned Council for the opposite party. Mr. Mahanti, you said that the copy of the review petition has not been solved.
No, neither
I
of me.
already have supplied
Like the faster Lekive, Mr. Ashok Mahanti and their advocate.
in course of the day.
Appearing for the opposite party, number 1, submits that in spite of the order dated 14/7/2025, the copy of the review petition has not been served on him. London Council for the state submits, Mr. Mahanti submits that in course of the day, the review petition copy shall be stopped. Mr. Rautray, have you received the copy?
No, till now we have not received, though your lordship directly.
Mr. Rautray submits. There was a direction also.
There was a direction also.
Same order for this. So now tell us that what would be the date.
I'll intimate after consulting with learned advocate.
Please also intimate the learned senior advocates the date.
I was only praying, can it be next week? This date of retirement is clearing day by day.
I'll come there after.
He will just contact the learned advocate general and apprise you, and taking the permission, he will give that date, we will incorporate. Whatever date both of you give, we will just.
No, I have no objection any date. Next
May
week.
be convenient to the advocate general.
But you're asking my, ask them to go, see, you would ask for 1 month, that cannot.
No.
Lordship, that I only submit that I shared with suspected with typhoid. It might require 2 weeks time for a recovery. That is the only prayer. But the matter is after 2 weeks.
Now, Mr. Learned Advocate General is to argue the matter. Okay. So
I bow down whatever.
Just date is to be fixed. We are not, but it should be on consensus. Okay, so that much we want. So let him obtain the instruction from the availability of the Learned Advocate General and also Mrs. Rothro, and intimate the date and see their convenience and tell the date, we'll incorporate that date. Okay, that much we want. Please tell us by lunch or
After the matter is finished.
and give the sir the copies.
Okay.
Review petition copies. Yeah.
Let him apprise the advocate general at least next week, any date to be convenient to it, we are ready.
Tell the concern of the land senior advocate. Yeah. Okay. Yes.
Item 33.
Also, in these cases, in the date 25 June, you have instructed us to deposit submit the order copies of the OA number 1196. So, as we have filed that copies, but there are some legible copies are there, some illegible copies are there. So, to help out the honorable court, it's some documents have out of that, which we have submitted. Out of that, some documents is precise to help out the court. I want to submit before the.
No, if this is not legible, then how it will be helpful to the court? If you yourself cannot read, so what is the purpose in filing those type of
That's it.
things?
Some of the documents, initial.
Just type it out. Just type it out, file it, give the true copy attested. That will do. But you yourself say that it is illegible. So
Still, Lordship, we have tried to bring out the legible copies.
type korantu, type karin file korantu. Take the time. Okay,
So-
don't file it. Keep it with yourself. File the type copy along with that copy which you have obtained, so that the type copy can be signed.
That they have filed eligibly.
And this
Type
is
copy.
the precise order copies, Lordship.
It's all right, you have, since you have typed it now, please go and file it. It will come on record, then we'll clear.
Have you typed it out?
Yes, some of the documents that I have typed.
Some of the document, what, the document which are not legible.
We have specifically stated, let the learned counsel for the petitioners file the
Order copies.
copies of the original application. ওটা তো দেখা যায়নি।
টাইপ করে ফাইল
টাইপ করে ফাইল করুন। দেখো না। The land counsel for you are Mr. Patnaik.
Yes, sir.
The land counsel for the central government council, Mr. Patnaik submits that he will type it out. The copy of the orders passed by the Central Administrative Tribunal, Cuttack Bench, Cuttack in OA number 1196 of 2004. Also order this court in confirming the same and file the same within a week.
That's like 2 days time because they have given.
We are giving you 1 week time. We are listing it on 11th. So in the meantime, you do the needful.
That's
okay. This matter in the week commencing from 11th of August 2025. Yes.
Item 34.
In this case, here the order passed by the London Central Administrative Tribunal is a subject matter of challenge matter. Here, the London CAT has directed the Union of India to refund the amount which has already been recovered from the applicant, the opposite party number 1. And here in this case, the opposite party, he was initially joined as a static assistant. Subsequently, he was
You had some excess payment of the dearness allowance.
yes, my lord, excess it has been paid. He has filed application that in the event this excess amount is paid, that will be refunded. Well, right now it was refunded from him, but the London CAT he has come to a conclusion that since other cases are considered and he is in the same footing, that is why this refund amount may be recovered from the Union of India. That is the subject matter of challenge file. Notice may be issued so that they will file their counter.
No, the principle of suffic mercy applies here.
My lord,
Suffic mercy
There is
principle.
no fault of the opposite party.
my lord, in fact, as per the rule 35 of FIR rule 35 of the department, my lord, in the event of excess amount is paid, that will be refunded. He has also filed application, representation, declaration also made that in the event I am officiating this post, in the event any extra amount is paid, it will be refunded from me. So accordingly, it is refunded after calculation. As for Annexer 1, if your lordship will
What
see-
about the principle laid down in that Rafik Masih case?
I beg pardon, my lord.
Rafik Masih, have you seen the judgment?
My lord, I have not seen this judgment, but
That's
I
the
will
judgment you
verify.
have to read.
But those are in similar
First
footings that
read
will be
that
considered.
judgment, then you argue. That's better idea.
My lord, I consider, my lord, in this latest Supreme judgment, as your recovery is concerned.
The learned counsel for the Mr. Pari give proper instruction to the learned counsel for the in this writ petition. The petitioners have wait for quashing the order dated 23/7/2024 passed by the Learned Central Administrative Tribunal, Cuttack Bench, Cuttack.
My lord, may keep you day after tomorrow.
Inter alia with other prayers. It appears that the writ petition was filed by the opposite party. Challenging the order of recovery of rupees 1,42,496 from his pay. And rejecting the representation against such order of recovery. The Learned Tribunal, after considering the ratio let down in the case of State of Punjab and others versus Rafiq Mishra, 2014 AIR SCW 6256 and other decisions of the Honorable Supreme Court, has been pleased to hold that since money recovered from the similarly situated employees has already been refunded to them, in view of the settled position of law and to maintain parity and equity, the order of recovery, so also the order of rejection of the representation were quashed, and the petitioners were directed to refund the already recovered amount to the opposite party. So, after placing the matter for some time, the Learned Counsel for the petitioner took some time to go through the ratio let down in the opposite decision of the Honorable Supreme Court in case of so and so. Put up this matter next week. Yes.
Can it be on Friday? Because the contempt is posted to 4th. That's something.
Place this matter on
Day after tomorrow.
1st of August 2025.
Too late.
Item 35.
May I please, Your Lordship? Lord, the order of Learned Central Administrative Tribunal is under challenge. Order is at page 163, annexure 8, Milord.
Delay and latches.
Only on the ground of delay and latches, this application was rejected, and Learned Tribunal lost sight of their own decision of that in the particular case, earlier division bench has already condoned the delay. Question of maintainability and the delay has been considered, that has been condoned, and thereafter matter placed for final pleadings completion. Then my matter was heard in finally, but Learned Tribunal, while passing the another bench has passed the final order, he has dismissed on the ground of
Where the delay?
Your Lordship may kindly turn to page 160, annexure 7, page 159, Milord.
Where is that?
Same case, Milord. 159.
The operative part.
Yes, 161, Your Lordship may kindly. It is seen from the above letter that applicant's name find place at annexure A by 11 at serial number such and such, and hence prima facie the tribunal finds that the applicants have a case, and since this is a matter of regularization, the delay is condoned. it has been submitted at the time of hearing that applicant number 4 such and such, then interim order was also passed, my lord. And the law and tribunal only on the ground that limitation dismissed, my lord.
Challenging the order dated 17/4/2025 passed by the London Central Administrative Tribunal in way number 260/00122 of 2020. The petitioner approached the London Tribunal with the following prayers. Fourth prayer that is mentioned in Roman 1.
Union of India?
Lordship.
I am for OP 1 and 2, Lordship. Right.
What do you say? If you agree, then we can remand the matter.
The case of remand,
It's
basically.
a question of delay and laches that has been. So,
Why do we waste time? Let it be heard on merits. Yes, on merit. Delay has already been condoned.
All right, also, the London Tribunal has been pleased to dismiss the original application on the ground of delay, laches, and limitation. The London Council for the petitioner referred to the order dated
26th January 2022.
28th January
2022, passed in email number 260/00117 of 2021. In which the London Tribunal, after hearing the Land Council for both the parties, has been pleased to hold that since in the letter dated 3/10/2003, the name of the petitioner find place hence the petitioner has a case, and since it's a matter of regularization, the delay was condoned. The Land Council further submits that after condoning the delay, the miscellaneous application was disposed of, the original application was admitted, and notice was issued to the opposite parties to file the counter affidavits. It is further submitted that an interim order was passed directing that the petitioner shall not be disengaged and if not disengaged, without the leave of the tribunal. It is the contention of the Land Council for the petitioner that when at the initial stage, the Land Council, the Land Tribunal, after hearing both the parties, has condoned the delay. At the time of final hearing, the matter should not have been dismissed on the ground of delay, laches, and limitation. Therefore, the order should be set aside and the matter be remanded back to the London Tribunal for adjudicating the case on merits. Mr. Mahapatra, London Central Government Council or Senior Panel Council has received the copy of the writ petition, and after going through the averments taken, the documents annexed, and hearing the Land Council for the petitioner fairly submits that the impugned order be set aside and the matter be remanded back to the Land Central Administrative Tribunal for adjudicating it on merit. We are also of the view that it was not proper on the part of the Land Tribunal to dismiss the original application on the ground of delay, laches and limitation, particularly when on 28th January 2022 in MA number so and so, the delay has been condoned and interim order has been passed. Hearing the Land Council for the respective parties, we are of the view that the interim order is not sustainable in the eye of law. Accordingly, the same is hereby set aside. Way number so and so is remanded back to the Central Administrative Tribunal, Cuttack Bench Cuttack. The Land Tribunal shall now hear the matter on merits. It is made clear that we have not expressed any opinion on the merits of the original application. Accordingly, the writ petition is allowed.
Obliged. One place your lordship observe that after that order of this delay is condoned, thereafter notices are issued. There the fact is little bit different. And this notice was issued, then they filed their objection, then delay condoned.
Come to that order.
Yes,
OA is admitted, notice be issued to the respondent to file the counter affidavit. We have seen from that order and dictated the order.
Last paragraph.
Page 161.
Paragraph number 162, come to them.
162.
MA is disposed of, then OA is admitted, notice be issued to the respondent to file the counter affidavit.
Earlier, sir,
No, whatever order.
Let us go by that order.
ସେମାନେ ଆଗେ notice କରିଦିଅନ୍ତି ଯୋଉଠି delay ଥାଏ.
Whatever order has been
Yes,
passed, we are just. Yes.
Let's see one more request.
Yeah.
Here I have appealed only for applicant 1 and 2. Other are there. So let's kindly confine them.
The Land Council just also appearing for opposite party number
1 and 2.
1 and 2. All
Item 36.
36, your Chief. Here I am for the petitioner, Union of India. Here, in fact, last occasion, the council is appearing for the caseator. I have already served the copy in the last occasion only, but the order says that the copy has not been served. My friend has received the copy in the last date only.
All right. Though a noting has come that extra copy has not been served on the Land Council for the opposite party, but Saraswati Mahapatra, Land Council appearing for the opposite party, submits that she has already received the copy. You are appearing for all the opposite parties.
In the meantime, 3 persons
Receive the copy of the writ petition from the Land Council for the petitioner. Yes, what further you want?
No, that much only, the clarification.
Now you have to argue for admission.
Yes.
You are ready?
Lordship, may I pray for a short time?
Tell us the date next week.
Yes, next week first.
Mr. Mahapatra, 6 for an adjournment till next week. Put up this matter next week. Yes.
Great.
Item 37.
May I please hear opposite party number 1 issued a notice for conducting auction over the 2 properties of Mr. R.N. Samant. Subsequently, the petitioner participated in the auction process and was transcribed as the highest bidder. Then a sale certificate was also issued. Now, the opposite party number 1 is coming with a conclusion that obtain the possession as well as the ownership from the opposite party number 2, which is absolutely detrimental to the rules under 2002 rules. Clause 8, rule number 8, clause 7.
8 rule of what rule?
Its rule is security interest enforcement rules of 2000.
Go to DRT and tell all this. Go to DRT.
DRT's jurisdiction is not coming here, because we aren't for any debt. We are coming because we were the auction purchasers. Subsequently, the possession and the ownership wasn't handed over.
You mean to say that it is the duty of the bank to get back the possession and hand it over to you? That is your submission.
Yes,
but they are not taking steps, rather asking you to do the.
Yes,
yes. What do you say?
I am the opposite party number 1. I am for the bank. Today I am authorized this item. Today I am filed the V nama.
No, you are filing the V nama. Now you have received the money from the auction purchaser. And you are not giving the possession, asking him to take recourse to section 14. It is your duty.
Taking instruction on.
Bank has to file section 14 basically.
Give the appearance. Why are you passing a slip? What is that?
On behalf of the BP, sir.
Why don't you file section 14?
Take
Recover the position and give it.
Take the instruction. Mr. Vibhuti Bhushan Swine Land Council appearing for the
Opposite party number 1.
opposite party number 1. UCO Bank submits that he has filed the appearance memo, Wakalatnama on 37/2025. Let the event come. Let the Wakalatnama be placed on record and the name of the land council for the bank be reflected in the clause list. The land council for the petitioner submits that the petitioner is the auction party here of the property in question, and he has deposited the entire amount with the bank, but in spite of giving him the possession of the property, the bank is asking him to take necessary steps to recover the possession, which is not legal and justified. The land council for the bank seeks some time to obtain instruction as to whether bank has filed any petition under section 14 of the Surface Act before the appropriate authority for recovery of the possession and handing over the same to the petitioner or not. Put up this matter in the week commencing from 11th of August 2025. If you have not done, in the meantime, you do it. Okay. Yeah.
Did you follow what order we passed?
Item 38.
Union of India has filed this writ application challenging the order passed by the learned tribunal. The tribunal order is at Annexure 1. Direction at page 29.
What was the prayer? Of the service rendered in
page 70. Page 70 of the writ application.
Institute of Medical Research under the Integrated Swan project as qualifying service for all purposes.
The opposite
Swan.
But Annexure 10 is the.
May I elect a few facts, my lord?
Yes.
Here is the fact is that admittedly he worked in the ICMR, there is a different projects, there is a scheme. The person concerned who is claiming that my previous working period should be taken into consideration, even though I work in the particular project or scheme, and it is a matter of fact that he has submitted his resignation. After the resignation, he is given a regular post. Our submission, their submission before the learned tribunal is that they basing on the judgment of Madras High Court, referring to Madras High Court, the Delhi High Court has passed an order. So he is entitled to get all the benefits. But on examination of the record, you see that the Madras High Court is negative this issue. The tribunal has rejected. Then Madras High Court has confirmed it. Basing on that, the Delhi High Court has passed order in favor of the department, not in favor of the petitioner. But the tribunal has wrongly misinterpreted and passed the order, which is want to put to the notice. When Mr. Bhukta will give a page wise. Annexure 7 is the most important document. This is this.
Have you challenged that High Court, Delhi High Court order?
That has been sustained by the Supreme Court.
Delhi High Court is not against us, my lord.
Then the benefit of that order has to go to these respondents.
Only that, my lord, in Rule 13 of the CCS pension rules specifically provides that if a person is initially appointed on a temporary basis, continues uninterruptedly, and which is followed by regular appointment in the same or another post, then in that case, the entire service will count for the purposes of a pension and pensionary benefits. Rule 13 of the CCS rules CCS pension rules 1972 has also been relied upon. Not only that, the Honorable Supreme Court in a number of judgments which has been quoted in the judgment of the Central Administrative Tribunal, starting, my lords, from Mahesh Chandra Burma, Prem Singh, then, my lords, Punjab and Haryana High Court judgment in Harwans Lals versus State of Punjab, against which SLP has already been dismissed. All those judgments have been relied upon by the tribunal to hold that if a person continues on temporary ad hoc basis in one post under the same department or another department, and which continues uninterruptedly till he is appointed in a regular post in the same or another department, then in that case, the entire service will count for the purposes of a pension and pension.
Not
Come to page
applicable to this
27.
case.
Come to page 27, para 11. 27, para 11.
Yes, my lords.
Read it out.
In the case in hand, the counter so also in the course of hearing, it has been admitted by the respondents that in compliance of the order of the Honorable High Court of Judicature at Madras, Chennai, and the Honorable High Court of Delhi, similarly situated employees engaged in the IDBC project or regularized with effect on the initial dates of a temporary ad hoc basis. It is also not disputed that in pursuance of the advertisement made by the council, applicant, while continuing under the same respondent as a senior research scientist, submitted application through his employer, that is ICMR, for the post of senior research officer under the ICMR, and after being selected through a regular process of selection, he tendered his technical resignation. The application dated 15th of March 2007, and thereafter, in application dated 16th of March 2007, he had intimated that since he has been posted at the field units and working as officer in charge, as such, he may be treated to have joined the post of senior research officer. From the above, it is established that the duties discharged by the applicant in IDBC project as senior research scientist on temporary ad hoc basis was the same and similar to that of the duties after his joining the post in the senior research officer. In fact, my lords, in the same office, in the same table, in the same thing, I continue even after my regular appointment. After joining, furthermore, kindly see. After joining, he was allowed protection of pay in the post of senior research officer under FR 22, as stated by the applicant, has not been disputed by the respondent. So when the pay protection is given, when the past service is counted. And then thereafter, the respondents have stated that since the applicant is continuing purely on temporary ad hoc basis under a project, his plea that he joined in the post of senior research officer after tendering technical resignation is not acceptable as per the DOPT-OM dated so and so. But we find that this plea has been taken by the respondents for the first time in the counter without any supporting documents to the above effect. After submission of technical resignation with a letter dated 15th of March 2007 and joining report dated 16th of March 2007 in the post of senior research officer, the applicant was allowed to continue in the post of senior research officer by the respondents, granting him all benefits including protection of his pay and his financial obligation, etc. with a order dated 12/19th June 2013, and thus when the applicant prayed to count the period of service which he had rendered under the IDBC project for the purposes of pension and pensionary benefits, denying the same on the ground that his resignation cannot be treated as a technical one, is an afterthought and is not acceptable in the eyes of law. It is, my lords, a sound principle commonly accepted that when a particular set of employees is given relief by a court, all other identically situated persons need to be treated alike by extending that benefit. Not doing so would amount to discrimination and would be violative of Article 14 of the Constitution of India, with the state of Uttar Pradesh and others versus Aravind Kumar Srivastava and others. As discussed above, since the compliance of the order of the Honorable High Court of Madras, Chennai and the High Court of Delhi, the similarly situated persons engaged on temporary ad hoc basis under the project have been regularized from the dates of their initial engagement, and the whole period has been reckoned for the purposes of pension and pensionary benefits. We see no justification to deny the said benefit to the applicant herein. Therefore, the rejection of the claim of the applicant deserves to be annulled. Accordingly, the impugned order dated 26th of April 2019 is hereby quashed, and as a consequence, the respondents are hereby directed to treat the applicant as an entrant to government service prior to 1/1/2004 and consider grant of pension and pensionary benefits by counting the period from 4/1/1988 to 15th March 2007, rendered in NIMR under the IDBC project, as qualifying service for the purpose of pension and pensionary benefits, the consequential action has to be taken. Now, my lords, further to that, 60 days time was granted to comply with this order. 60 days time got over in the month of April.
My lord, may I submit, my lord?
Then thereafter, what happened, my lord? I filed a contempt petition. That contempt petition is pending. They have appeared before the contempt petition. These facts have not been mentioned in the writ petition at all. This amounts to suppression of fact. When a person gets an order, a direction from a competent court of law with a direction to comply with it in a particular period of time, after the period is over, a contempt petition is pending, and they are facing contempt proceedings before the tribunal. Was it not a material fact to be disclosed before this honorable court? The entire thing has not been mentioned. And they have stated as if they have
we'll file a petition, then they will argue.
Supreme Court as well as other high courts have deprecated. I have got those judgments with me. Ready.
Just when the contempt petition was filed.
Well, the contempt petition was filed on 8th May 2025, 8th June 2025.
Okay. Now,
and 18th June 2025, the learned advocate Mr. A.K. Mahapatra appeared on behalf of the petitioners before the tribunal.
And this writ is filed on 3/7/2025.
CP number 31/2025 also was filed before the CP number 31/2025, filed on 8th June 2025.
Okay, that was, and the appearance was made by the
learned counsel Mr. A.K. Mahapatra
for the contemners.
For the petitioner hearing ballots. And on 18th of June, that was the date of hearing, was 18th of June.
So have you mentioned all these things?
No, madam, they have not mentioned. They have not mentioned.
No, about contempt application, I have not mentioned.
So,
admittedly, contempt application, I have not mentioned.
My lord,
when you are filing the case in July 2025, and you are already facing a contempt petition, and the appearance has also been made, are you not supposed to disclose all the facts in the writ petition?
Yes, that has to be brought. Contempt application, since I am challenging the order of the tribunal, I have not mentioned contempt application.
No, you are supposed to know.
That I have
these things have been held to be suppressed.
By the way, what is your submission?
Your Lordship kindly have a glance.
When the similarly situated persons have already got the relief, and those orders are being passed by different high courts, and it has not been challenged in the Supreme Court.
No, madam, they have been challenged in the Supreme Court and SLP dismissed.
That is not mentioned in that imposed order, of course. So, that has been also
in the judgment, the learned tribunal has not mentioned it. However, the matter of fact,
brother,
High Court,
one by one.
the SLP has been dismissed, and against the Delhi High Court, SLP has been dismissed. In fact,
Mixer Bhutan clarify one has a fresh mail. Yes. Let them have a patience. He'll clarify one. Yes.
Lordship kindly have a glance to page 70. Page 70. Page 70 of the judgments.
Another conduct matters may kindly say. My learned friend has filed a copy of the OA which was filed before the tribunal without all annexes. He has filed his counter only with the annexes. Or the entire OA, he has filed only the OA portion, the entire annexer he has omitted. The rejoinder filed before the tribunal, he has totally omitted. What is this kind of conduct? You are coming
for this. What omitted?
The annexes includes with the
original application was filed.
The original application he has filed. Page number 45, kindly have a look at Mellor.
Now, what he says is
original application
selective documents.
Documents because
pleadings means pleading. The entire pleading has to be placed before the writ court.
We are consistently telling you that when you are challenging the order of the London Central Administrative Tribunal, all the pleadings should come before us. Because if you are only attaching the original application, but not the counter affidavit, not the rejoinder affidavit.
Why are you so selective? First of all, you don't disclose what has transpired after the impugned judgment. Second, you selectively file the documents.
Have you filed those documents? Let us be clear. Have you filed?
No, I have not filed. Because some of the documents are not legible. Only I am challenging.
When you have filed your counter affidavit, and
then Lordship may fix you some other day will file additional affidavit. We'll file everything. Let us clear.
It was
Transparent
your
to the court.
counter
Yes.
affidavit. Now you are telling that it was not.
Rate
placed.
application, original application.
Original application.
Original application along with documents. ma'am.
Original application, no annexes filed. Rejoinder, no annexes filed.
Yes, yes, rejoinder is totally omitted.
So rejoinder not filed at all.
Rejoinder not filed at all.
Okay.
Original application, only the OA portion has been
Okay,
filed, but
yes.
all the annexes have been omitted.
Annexures not filed. Okay. Then rejoinder not annexed. Okay. Counter affidavit he has filed.
Counter affidavit is annexures he has filed.
Okay.
Only the counter affidavit is annexed he has filed.
Just a minute. Just a minute. This writ petition has been filed by the Union of India challenging the order dated 31/1/2025 passed by the Central Administrative Tribunal in OA number 260/00692 of 2022. Under Annexure 1. On perusal of the impugned order, it appears that the opposite party, Dr. Manoj Kumar Das, filed the original application with a prayer for a direction to the petitioner to count his service from 4/1/1988 due to 15/50/2007 rendered in National Institute of Medical Research (NIMR) ends under the Integrated Disease Vector Control IDVC ends project as qualifying service for all purposes, that is pension and other pensionary benefits, by quashing the order dated 26/4/2019, wherein the petitioners rejected his representation. In this said case, the petitioners filed the counter affidavit, and thereafter, from the side of the opposite party, the rejoinder affidavit has been filed, and after considering the cases of the parties and taking into account the decisions, several decisions of the Honorable Supreme Court, the London Tribunal has been pleased to hold that when the Honorable High Court of Madras, Chennai, and High Court of Delhi has granted relief to the similarly situated person engaged on temporary ad hoc basis under the project and regularized them from the date of their initial engagement, and further passed the order that the whole period has to be reckoned for the purpose of pension and pensionary benefits. There was no justification to deny benefit to the opposite party, and accordingly, the rejection of the claim of the opposite party was annulled, and the order was quashed, and the petitioners were directed to treat the opposite party as an entrant to the government service prior to 1/1/2004, and to consider grant of pension and pensionary benefits by counting his period of service from 4/1/1988 to 15/3/2007 rendered in NIMR under the IDVC project as qualifying service for the purpose of pension and pensionary benefits. Stop. The London Council for the opposite party submits that the orders passed by the High Courts of Madras, Chennai, and High Court of Delhi were challenged by the petitioner before the Honorable Supreme Court, and the SLP were dismissed, which is not disputed by the London Council for the petitioners. A preliminary objection.
My lord, you are disputing, my lord. This case was not been dismissed.
Stop. the Learned Counsel, the Learned Deputy Solicitor General disputes the submission made by the Learned Counsel for the opposite party. Let the SLP orders passed be filed by the Learned Counsel for the opposite party. Stop. The Learned Counsel for the opposite party further brought to the notice of this court that the impugned order was passed on 31/1/2025, wherein the direction was passed to make the compliance within a period of 60 days from the date of receipt of the order. Is further submits that since the order was not complied with during in stipulated period, the content petition was filed by the opposite party before the Learned Central Administrative Tribunal, which was registered as CP number 31 of 2025, and it was filed on 8/6/2025, and the contemner has already entered appearance on 18/6/2025, and this writ petition was filed on 3/7/2025, and there is no averment in the writ petition relating to the filing of the contempt petition.
And in the application for stay also nothing is said.
And so also in the application for stay, which was filed, there is no mention about the same. The Land Council further submits that though the copy of the original application has been annexed to the writ petition as annexure 10, but the annexures filed to the original application have not been annexed, and the rejoinder affidavit filed by the opposite party has also not been annexed. Stop. At this stage, the Mr. Gupta Lanen, Central Government Council submits that he will not only file all the annexures to the original application, but also the rejoinder affidavit filed by the opposite party before the London Central Administrative Tribunal, and make necessary amendment and file an application for necessary amendment to the pleadings taken in the original in the writ petition by incorporating that a contempt petition has been filed, and about the status of the contempt petition. So also in the interim application for stay. Stop. A copy of the this order passed by the Honorable Supreme Court in the SLP dismissing the petition filed by the Union of India be served on the Land Council for the petitioners in the meantime for taking instruction on this and put up this matter on in the week commencing from 11th August 2025.
Yes, Mr. Vera, 11th August.
11th August.
11th August 2025.
11th August.
We commenting.
No, 11th August.
On 11th August 2025.
Appearance.
Please. Abhay Kumar Behra and Senior Advocate files the appearance memo which is taken and read for him.
My lord, I apologize that even though my lord has repeatedly told us to file the affidavit with all details, we have
Actually,
yes,
it's not proper. Actually, the entire
it's not also. We are meant to transparent to the court. Yes,
everything should come before the court and the parties. We are expecting
those documents are not legible. We have to file the type.
At least Union of India should do that.
No, definitely. It is better, my lord.
Yes, sir. Next.
Sorry, yes, extremely.
Item 39.
Here, my lord, petitioners are challenging the order of DRAT, whereby the appeal filed by the petitioners were allowed, but the essay filed by them was dismissed.
No.
Where is that?
Who are you? Let us speak. You are
My lord,
applicant in essay.
just explaining, my lord. My lord, petitioners are the legal heirs of the mortgagors.
Okay.
My lord, the property, the loan was taken by the opposite party number 3, a proprietorship concern, my lord, of whom, my lord, opposite party number 4 has given some property for mortgage to secure the loan, and late Vijay Kumar Rai, the father of the petitioner number 1 and petitioner number 1 and 3 and husband of the petitioner number 2 also created equitable mortgage of his property, my lord, for 40 lakhs of rupees. My lord, the opposite party number 3 could not pay the dues of the bank. Therefore, the bank initiated SARFAESI proceedings. Under section 13(2) of the SARFAESI Act, my lord, notice was issued under annexure 1, my lord. They could not pay the dues of the bank. So therefore, my lord, on 22/3/2012, symbolic possession under section 13(4) was taken over.
Yeah.
That is under annexure 2, my lord. The property, annexure 2 is the property of late Vijay Kumar Rai. So therefore, they initiated, therefore, thereafter they could not pay the dues of the bank. So they proceeded for auction of the property. So auction notice were challenged before the petitioners at different point of time. Petitioner number 3, my lord, at different point of time, my lord. In the meantime, what has happened, my lord? Annexure 4, your lordship may kindly have a glance to page 39. The mortgagor, late Vijay Kumar Rai, expired, my lord, leaving behind these petitioners as the legal heirs, my lord. So the bank went for auction. The auction notice was challenged before this honorable court in WPC number 919 of your lordship may kindly have a glance.
Just
to
tell us.
page,
Don't tell the number. Just tell the what has happened.
Challenge. The wife of the Vijay Kumar Rai challenged before this honorable court. The matter was placed before the Lok Adalat, my lord. And in the Lok Adalat, the petitioner number 2 and the bank entered into settlement that the loan will be settled in terms of the OTS 2012 scheme, 16 scheme, my lord. But thereafter, my lord, instead of, my lord, settlement of the loan dues in terms of the order of the Honorable High Court and the Lok Adalat, they again put the property to auction. And no notice was given to the petitioners, though they are entitled to the notice, and sold the property. The petitioners, being the legal heirs, challenged the auction sale notice as well as the rejection of their OTS settlement, which was arrived at between the parties at the Honorable High Court.
Yeah.
So the DRT said in a SARFAESI application under section 17 of the SARFAESI Act, the knowledge presiding officer DRT, without any analysis, without verifying whether mandatory provisions of the law have been followed or not, he has only one line he has said, recorded the submission of both the parties and said bank has complied with all the relevant provisions of law. Therefore, I am not inclined to interfere with the auction sale notice, and I cannot set aside the rejection of the OTS letter.
You came in appeal.
Then we went in appeal. The appellate court also did not examine anything, said that what has happened, my lord, the DRT said that apart from all these things, holding the principle of natural justice, you pay 50 lakhs to the bank. We challenged the same before the appellate tribunal, saying that tribunal has committed wrong, not setting aside the auction notice and not even setting aside the rejection of the settlement proposal. The appellate court said that the tribunal has no power to direct 50 lakhs of rupees for redemption of the property and did not examine the validity of the auction sale notice. So hence we are before.
No, did not. Then it should have been remanded.
He should have remanded because it has not been dealt with. Infraction of law has not been dealt with.
Let us see the operating part of the DART.
Why not?
Appellate.
300.
Annexure 19.
My lord, annexure 19.
Come to the operative form.
My lord, para 31, on the basis of the discussion made above, I am of the considered view that the learned DRT has committed a patent illegality.
Para
31.
page
Page 314. Annexure 19. On the basis of the discussion made above, I am of the considered view that the learned DRT has committed a patent illegality in passing the impugned order. It is liable to be set aside. Accordingly, essay is also liable to be dismissed. The appeal is allowed. The impugned order dated 29/2/2020 is set aside. Consequently, essay 38 of 2017 is dismissed.
No, but your application was allowed. That
But appeal was allowed, essay was dismissed.
Oh, then you.
But the bank has not challenged the
that.
order of the DRT. In my appeal, he has set aside the.
All right, the writ petition has been filed by the petitioners Smruti Ranjan Roy, Kanak Roy, and Vishwaranjan Roy, challenging the judgment and order dated 22/4/2025, passed by the Land Debt Recovery Appellate Tribunal, Kolkata, in regular appeal number 23 of 2023. And though allowing the prayer made by the petitioners in setting aside the order dated 29/2/2020 passed by the London DRT Cutter in essay number 38 of 2017, but all the same dismissing the said essay. Stop. The Land Council for the petitioner referred to the impugned judgment and submits that though the London DRT has assigned good reason for setting aside the impugned order passed by the London DRT, but all the same, it should have remanded the matter to the London DRT for adjudication of essay number 38 of 2017, as the London Debt Recovery Tribunal has not taken into account inter alia the order of this court passed in the Lok Adalat directing for
Settlement of the loan account.
Of the loan accounts.
In terms of OTS 2016.
In terms of the OTS property.
OTS 2016.
OTS 2016. Where is that order?
My lord, annexure 7, my lord.
He also referred to the order dated 11/2/2017, which was passed in the Lok Adalat in WPC number 919 of 2016, wherein specific orders have been passed that both the parties agreed that the loan amount of the petitioner shall be settled in terms of SBI OTS Manufacturing, Trade and Services 2016. And accordingly, both the parties filed the compromise petition to that effect, which formed the part and parcel of the order. Stop. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. requisites shall be filed within a week. Matter be listed after 4 weeks. Yes.
My lord, I have prayed for interim prayer, my lord.
What is the interim?
My lord, only the auction purchasers shall not create third party interest.
IA number so and so. After considering the averments taken in the interim application and hearing the land council for the parties as an interim, it is directed that the opposite party number 5 opposite party number 5 shall not create any third party interest and shall not change the nature and character of the land till the next date. List this matter on such and such, give a date. Yes.
Item 40.
We are just coming within.
Item 40.
Made, please, my lords. Well, someone appearing on VC, my lords. Item 40.
Yes.
This is a matter where your lordship had already interfered in one of the matter. The issue is, my lords, whether the learned grievance redressal forum contains a jurisdiction to decide the question as to the shifting of substation or electricity transformer.
Where is that order, the earlier order?
My lords, if your lordship sees, my lords, the order is at
Hey, Nandi, is it that? Why someone is not there? Here you are challenging annexure 7.
yes, my lords.
Come to the operative part.
My lords, annexure 7, your lordship will see page 36 is the operative part.
Okay. ऑर्डर को देखिए कि नहीं ये ऑर्डर को ये करी बाकी जहाँ सब अच्छी है ना सब करिए और land 80 लिख देवे land council for the petitioner submit that in similar matter that is in WPC number so and so notice has been issued on the question of admission. এটা লিখিং তারপরে এই যে পোর্শনটা ইস্যু নোটিস you file the copy of the order তারপরে বাকি তক রইবে না নিয়ম.
Well, there is also the IA interim prayer.
Same order is to be.
Yes, my lords. Deeply obliged.
Item 41.
But so the matter relates to the Surface Act, my lords. The impugned order, my lords, next for 5 days, 20, my lords. The petition is a widow lady, and she had availed a housing loan from the opposite party, 8,60,000, and he was paying. Subsequently, after a death of the husband, she defaulted, my lords. For which annex 5 that the possession order has been issued, my lords.
No, you go to the appropriate.
My lords, I am not on the merit, my lords. This is a widow lady. She is ready to one chance may be given. One chance, my lords. Some time may be granted, 6 months time and 6 installments. He will comply. And
He'll tell the same thing before the DRT.
One opportunity be given.
No.
to
Once the
redeem his
petition is not maintainable, here in view of the decisions of the Honorable Supreme Court, our decision,
Yes, ma'am.
how can we give you time for 6 months to do the needful in paying it? Once it is not maintainable, go make the similar prayer, get the relief, and negotiate with the opposite party, do the needful.
I'm conscious of that, my lords, only on humanitarian ground. my lords.
The petition has
My
been
submission
filed,
may be
challenging so and so. Parties decisions should have proposed for the alternative remedies available. Yes.
my submission may be
21 देखो 20 outlook.
Put the eyes mark and like
The
this.
signature, very fanciful signature. Mr. Raut, R.N. Raut.
Hey, কি করা আছে?
What is this?
Signature তো আখি কোন ওটা করছেন নালি আরে No, why?
Is there any significance of this?
What do you mean by that?
That's only for astrological.
In the Vokalatnama also you have done.
My lords, I'll not.
Don't do that. That
Yes,
looks
yes.
nice. In the Vokalatnama also you have seen.
I should be aware.
And that too in the red
Yes,
pen.
my lords.
Vokalatnama you have seen.
ଦସ୍ତଖତ ତଳେ ରେଡ୍ ପେନ୍ ରେ ବୁଲା ହଉଛି ଆଖି ଚିହ୍ନ ହଉଛି କଣ ତା ମାନେ କଣ? My lords, I will not.
Avoid it in
No
judicial
special only
recording.
for astrological, I will avail. Yes, I will pardon.
Yeah. Next.
Item 42.
I please, Lordship, my lord, this is the petition for amendment of the petition only for correction of the address statement. But before your lordship, as per the direction of your lordship, I have made the corrected amendment petition.
No, the CMAPL, we have on the question of limitation, we have already
issued
notice issued.
Yes,
But further you want?
no, notice was returned due to the address is not found incorrect.
Correct.
Your lordship may kindly see the last note of the office.
Last note means one.
26/3/25, there is an order of judicial
Notice in the
order.
admission so and so issued to sole opposite party through so and so
Yes, yes.
at the date of appearance. তারপরে কোন হলো?
And there was an office note that
Notice
the
in the
address
admission
was
not
not
found.
found, so the notice returned, my lord.
She cannot be found.
Thereafter, your lordship said that you should amend the cause title and also the correct address of the plaintiff, of the opposite party.
Have
So
you
I have
filed?
corrected, I have filed this amendment petition bearing IA number 375 of 25. my lord.
IN number 11, IN number 375 of 2025. There is an application filed by the petitioner, State Bank of India, for amending the petition and mentioning the address of the
Sole opposite
party correctly. Stop. On perusal of the noting of office note, it appears that notice in the limitation matter issued to the sole opposite party returned on delivered with postal endorsement inverted comma bhitere addressee cannot be located. Stop, hence return to sender inverted comma ends. In view of such office noting and the prayer made, the prayer made in the interim application is allowed. The you furnish that correct address in the consolidated
consolidation by Monday, along with fresh notice. I humbly submit
the consolidated cost title incorporating the correct address of the sole opposite party be filed by 4th of August. 5th of August 2025.
And office to issue notice again.
And the on filing of the same, the office shall issue press notice for which requisites shall be filed by the petitioner also by 5th of August 2025, fixing a date of return. Yes,
Item 43.
IA is disposed of.
Item 43.
May it please, ma'am. Lord, in the informed case, the petitioner challenges the forfeiture of the deed amount, that is to the tune of 5 lakhs, my lord. My lord, here the case goes like this. Annexure 1, my lord, page 7. That was a
Mahapatra, you are appealing for the
State Bank of India.
Notice.
Forfeiture of amount which has been deposited in auction. 28%.
And what is the second writ petition which is there?
second writ petition challenging the action of the recovery officer. My lord, in this case, what happened? The petitioner, pursuant to the advertisement, that auction notice, he became the successful bidder, my lord. My lord, thereafter, at page 8.
You are placing the first matter.
Yes, my lord. First matter.
Page 8.
He was qualified as a successful bidder, my lord, and page 8. The property mentioned herein, flat number E103, 4th floor, Astray apartment, such and such. received a sum of 4 lakhs towards the caution deposit. My lord, thereafter, page 9. I have paid total 5 lakhs towards the bid amount. That is 25% of the said bid amount. My lord, thereafter, the petitioner came to know that there was a suit pending pertaining to this property since 2007, and for which he could not deposit, he did not feel proper to deposit the rest bid amount.
Where have you said that?
Yes, my lord,
Intimated
it
them.
is at my brief.
No, where have you intimated that pendency of the
My lord, on 29/11/11.
which letter?
My lord,
Which letter?
Which is that letter?
a letter I have not annexed.
Then
I have mentioned in my brief, my lord, on 29/11/11, my lord. That is that the opposite party not to proceed with the auction as because the property in question, which was involved in the auction sale, suffered from various litigation. The petitioner on 29/11/11 requested the opposite parties not to proceed with the auction and return back his initial deposit, which was made by the petitioner.
Are you reading this line
My lord, from page 4, my lord, para
of your
11.
petition?
Yes, my lord.
That letter is very vital, ma'am. So, page kete, paragraph kete.
Paragraph 11, my lord.
So, the bank should be made aware
Yes, my
that
lord.
when you are deposited
Yes,
a
ma'am.
part of the amount, why are you not depositing the rest of the amount?
Yes,
So,
ma'am.
if you are not communicating the same to the bank, but keep it with yourself, then obviously they will take steps that the balance amount is not deposited. Then, as per law, they are proceeded and they forfeited that amount.
Yes, my lord, they have put.
And in that suit, bank was also not a party.
Yes, my lord, I bow down. I bow down to that, my lord. My lord, after assuming but by not admitting, if I would have paid that amount, 15%, because the judgment already been decreed against the borrower, my lord, and the property could not be delivered to me because the fast charge on the property is under the suit, my lord. And my lord, thereafter, I have intimated on 18 April 2012, Annexure 787.
So as that the auction notice, they have said that it is free from all encumbrances except this.
Yes, my lord.
Have they represented that this is free from all encumbrances?
Yes, my lord. My lord, in the auction notice, that is.
But there is no dispute, land counsel for the bank.
Milord, I will explain what happened.
Just one line.
Suit was pending.
That the suit, the property which is involved in the suit,
Milord,
is the very property for which he became the successful auction purchaser,
Milord,
and you also received 25% of
Milord.
it. So there is no dispute.
The dispute is that what exactly when we have put the notice on auction, we are not aware any suit has been filed
And you
in
just
2007.
try to be practical.
Milord.
5 lakhs she
5 lakh received
1 minute.
Milord.
And thereafter she came to know that there is a suit pending. There is a decree.
Milord.
And 5 lakhs
I am coming.
he has spent. And again he paid.
Milord, I am coming to the fact. If it is pending within 15 days or thereafter within 3 months, we have rejected in the month of December, and it was held in the month of September, the auction, and then in between he has not brought to the lady has not brought to the what is the game, Milord? The lady is in the rent of the owner who has mortgaged the property. She is a henchwoman and she has participated knowingly fully well everything where bank was not aware, and thereafter 25% after depositing she tries to derail the entire process. Now what happened? She has no locus standi where we have got the decree. Now she has appeared before DRT and saying that DRT should not proceed. What is the locus of the rent auction purchaser? In one hand, she is saying you refund my amount which has been taken, and now she is there in DRT before the recovery officer. Don't oust me. I am already purchased the land. So totally, Milord, appropriate.
She is in possession.
She is in possession because she is in rent. Because the original owner is not coming for. Who is to file, Milord? The original owner. if suit is decreed in favor of the original owner, he should come and say that it is what is in mortgage, that is a fraud or something like that. He has not said anything. What I suggest, my lord, the Supreme Court has categorically stated in 3 judgments. First judgment, Supreme Court has said it is not maintainable. She should go and section 17(1) approach the DRT. Second judgment, the Supreme Court in 3 judgments has said, even if you have not deposited and it is not at bank fault about the suit or anything pending, even if there is an order of the DRT, Supreme Court said that the Surface Act is a special act.
Now,
And the forfeiture
who is the plaintiff in the suit?
Original
owner.
Original owner.
And
Then actual story.
tenant
I'm telling the story. What happened? The purchaser, our borrower, who has purchased the flat from a particular person, and that particular person purchased from a developer. So developer and the landowner, there is a dispute. Landowner cancelled the power of attorney and filed a suit. So the developer and the owner, that suit came before the civil court, and subsequently my borrower was a party there. And after the civil court said, once this power of attorney has been cancelled, the landowner is now the owner of the property. So what has been sold by the developer, so that is null and void. So question is, my borrower is also not the owner. So who should come? The landowner is to come. Nobody is coming. Now because she has been as an agent of the borrower come forward is putting her that you go and derail it so that I can see somewhere else. So I will just bring to your lordship notice, the Supreme Court has categorically stated it is a statutory forfeiture. It is not that bank is unjustly enriched, number one. Supreme Court has also stated, my lord, that even if suppose the money is refunded, then how the bank will go for getting it? So the section 73 and 74 of the Contract Act, they say this will not applicable. Bank will not go for filing again a suit against the option purchaser. It will be preposterous. And it is ridiculous. And they say this type of borrower who is putting somebody else to derail the entire process, so subverting the entire process and destroying the entire process, that should not be countenanced. So accordingly, the Supreme Court 3 judgments, I will show the judgment.
Let us be clear.
Yeah, Miller.
Is there any doubt that he was the successful auction purchaser?
She participated, declared as the highest bidder.
In yes or no? Whether
he is the highest bidder, Miller.
Highest bidder.
And only after giving the entire money.
You did not accept the money which was offered to by him, 5 lakhs at
5 lakhs because the day
କାରଣ ପଛରେ ଇଏ କରିବେ ଆପଣ ଅକ୍ସନ ସେଲ ନୋଟିସ ଅନୁଯାୟୀ 17/11/2011 ରେ did you not ask him to deposit the amount?
Yes, we have asked
whether he has not.
See, we are let's come to the
if
annexer 3 annexer
when the property was mortgaged with bank.
Mortgage in 2008. When
2008.
Yeah, 8.
1 minute. 2007 suit was pending.
Suit was pending.
Why the bank has not done due diligence and accepted a property which was subject matter of a suit?
That is the suit. Bank was not party because
bank not due diligence you have done.
Due diligence has been done because there was in the court.
You come to that point.
The fault is on your part.
Bank.
If you would have mentioned in that auction,
you accepted the property which was subject matter of a suit without due diligence, and auction it. A third party purchases it and pays 5 lakh rupees. When he discovers that there is a suit, he asks back money. As simple as that.
Millard,
that fault is it? It is the bank officers.
No. Millard, what I am submitting at that time when it was there, suit was filed in 2000.
You answer it. If the mortgage was done in 2008,
then I will.
When the suit was pending in 2007,
Millard,
what due diligence your officers have done?
So I will then take time to figure what is Millard. Then in that extent, I will go and find out whether the opinion has been taken, whether bank has done the due diligence or not.
The laches is in your part. You are not disclosing the. If you would have mentioned in that auction sale notice that this matter is the subject matter, this property is the subject matter of a suit, and the suit is pending.
Sir, bank is not a party. Bank is not aware.
No, we are not. So
how do you
has to be
fix
done
the
by-
liability now? He is
The
the
liability,
innocent man.
because Miller,
She is innocent. She, on the basis of that auction sale notice,
Miller.
she applied and she was the successful.
applied and she did not pay, Miller. What I am saying, she
Pay
did
on
not
the
pay
ground.
within the time.
Who is that policeman who will deposit the amount after depositing the
5 lakhs, is it
5 lakhs?
costly?
When he
How
comes
people
to
are
know that even if I deposit, I will not get back because the suit is pending.
Then the
Should be
suit is
police
pending,
enough
Miller.
to
It was,
deposit.
bank was not party. Bank was not aware about the suit. So how could bank will able? Otherwise, bank would have disclosed
You
it.
will pleaded
Miller,
ignorance and if for your latches, a person will suffer
Miller, this is not the latches of the
and you will forfeit the amount.
Clear latches.
Then Miller, it is a statutory forfeiture, and because of this, bank is not
Statutory
at
forfeiture provided that you should have been clean enough.
No, Miller, it is not bank.
Fraud
Bank
like which
has not.
you are committing fraud on a person who has deposited
Miller,
that amount.
bank has not committed, Miller.
Yes, you what before if the suit is pending, how can you put that matter on the auction sale and you will receive the money, issue letter him to deposit the money?
Miller, when the suit was filed, bank was not aware. Bank was not aware even whether this is pending or bank was not party.
No.
If bank was not party, bank was somebody filed somewhere else. We have taken the
If the absolute ownership is not there,
Miller, I will
title is
just-
not
I will
there,
just-
you
I
have
will just-
accepted that as a collateral.
Miller,
How have you accepted that as your collateral?
Miller.
If the absolute title was not there,
we have taken the title deed. Title deed means the
what title deed? Show us the title deed.
The
There
title deed
can't
is-
be a title deed.
Miller,
Because the dispute was going on.
No,
Can't be
Miller.
a title deed.
Dispute was filed. We are not aware whether dispute was filed or not. Then we have just seen the title deed, original title deed.
Oh, original title deed of
Did
whom?
from the borrower purchased from somebody else, not from the builder. So builder sold to somebody else. Somebody then sold. I just
That is the due diligence. You
No, Miller,
have done
it is Miller. It is
You are
because Miller.
You have a panel of lawyers.
No,
and
no,
all
Miller,
of
I will satisfy in the way when he has purchased the property.
My lord, as per section 87A of security interest rules, there is a clear provision, my lord, the description of immovable property to be sold.
Miller, I am wrong, Miller.
Of the income
Actually,
known to the secured creditor. It is there in the.
You are always wrong. You are wrong in putting that property in.
No, Miller, it is 2000, Miller, it is 2004, Miller. Actually, it is 2004.
Beginning.
2004, the purchase, the property has been purchased and thereafter it is mortgaged. How could we know, sir?
You file the documents.
Miller, document is here, Miller. Only sold it. They have annexed. Miller, they have annexed. It is in 2004, conveyance deed executed. So bank has taken after 2004 conveyance deed. How could a bank would know that the suit is filed thereafter? Miller, I will give the details, Miller. You give me time, I will give the details. Bank is not at fault. Bank is no way connected, and bank
She is also not at fault.
Miller, she has to.
I will ask as it is stuck.
No, Miller.
When you are forcing
Miller, come to notice. Come to the notice.
File
notice.
File the document.
No, Miller. Auction notice. Miller, your lordship, there is a due diligence. 15 days time is given for due diligence. Your lordship come to sell notice, Miller. I will go term one by one.
File those documents.
Don't argue in
It's not so simple.
No, Miller, your lordship come to this. Miller, come to the sale notice.
Don't argue in a piecemeal manner. You
Bring those documents on record. It's not so simple.
I will bring all the records.
Land Council for the petitioner pays the matter. The Land Council appearing for the bank submits that he wants to file a detailed affidavit annexing some relevant documents and serving a copy on the Land Council for the petitioner, and the matter may be taken up after a week. List this matter in the week commencing from 11th of August 2020. Yes.
Item 44.
May I please answer? But the writ application was filed challenging the registration of EPML case, and thereafter matter was granted stay, interim order was passed. Subsequent to that, during the pendency of the application, 3-4 developments has taken place. In 2020, a PMLA case was registered against the principal accused, and that was pending before the PML. But in the meanwhile, the schedule offence case that was arising out of the vigilance case filed before the Keonjhar Vigilance Court, that was quashed by a judgment of the Son of Court in 482. that I have filed in my IA. That's if I kind branch to the IA 16881.
You have little elaborated in that order dated last order 14/7/25. That what is your prayer? Then
The conflict has been filed.
Agrawal pointed out
The number is to be corrected.
that right.
That is been correct.
The issue has already been settled by the Honorable Supreme Court, where the provisions have been offered, the virus has been offered. Then
That's super par. The prayer 1 is concerned.
right now, some ECIR number has been mentioned wrongly. That you said that
I made an amendment application.
that is allowed.
That was allowed by my lord, and I
Let us see your two prayers in this writ petition.
But for the prayer 1, it has come to division bench. If the first prayer goes, it has to go to the single.
No, my lord, let me come. My lord, the situation is the whole case which has been entire writ application which has filed, in fact, has become almost zero. The reason being, my lord, there was after the schedule offence was quashed by the Vigilance Court, by the Honorable Court in 482, the accused has been discharged. So there is no schedule offence. Thereafter, my lord, another case was filed by the principal accused before the Honorable Supreme Court, taking the judgment, and the Honorable Supreme Court quashed that thing. Now, my lord,
Mr. Mahapatra, please come to your prayer. So, so far as number 1 is concerned, it has already been settled.
Yes, ma'am.
Please come to the prayer portion.
My lord.
The second one is
Quashing of the
quashing of the PMLA Act proceeding. You said that has now that proceeding is not there because what is your submission? The charge sheet has not been filed under such offence?
No, my lord.
No, in predicating offence, you have been discharged.
Out of the schedule offence, my lord, the PMLA proceeding is initiated. The schedule offence has been quashed by the Honorable High Court in 482, and the accused has been discharged. Thereafter, my lord, the principal accused who was prosecuted under section 44-45 of the PML Act, he's also been discharged in view of the Supreme Court judgment. Because there is no schedule offence. After that,
what further remains? What further remains?
Further remains nothing. Only lordship is to dispose of the application.
All right.
Taking into account.
One line, my lord.
Let me come.
There is nothing we are dismissing.
One line. Prayer 2, Lord. Prayer 2, please. Prayer 2.
Let me complete.
Prayer 2 account kun. Issue so and
so initiated against the petitioner under the Prevention of Money Laundering Act herein are PMLA, and further pass directions quashing all actions and prosecute. Till date, we have not initiated any prosecution against the petitioner.
Just a minute.
So this writ application become infructuous, my lord.
Premature.
Premature, my lord.
Premature.
Premature.
That is the reason, my lord. The affidavit filed by the ED. Kind of a glance to the affidavit.
No, we will record that submission.
Yes.
That no prosecution has been initiated.
Yes, my lord.
Yes.
Under
So
PMLA,
Para 6, my lord. Para 6 of the
affidavit, my lord, because in the IA they made some prayer to
now
classmate.
we are
so we record
Yes,
the
my
entity and
lord.
dispose it out.
Yes, my lord.
all right. The
Para 6 is important.
all right. The writ petition has been filed by the petitioner with the following prayer. For the two prayers. As per that order, previous order, there is no dispute that in view of the decision of the Honorable Supreme Court in the case of DJ Madan Lal Chaudhary versus Union of India, reported in 2022 SCC Online, SC 929, the issue has already been answered, and the provisions of the Prevention of Money Laundering Amendment Act 2013 has been offered. So far as prayer number B is concerned, the Learning Council for the opposite party number 2,
Para 6 of my affidavit
submits that no prosecution has yet been initiated against the petitioner. Therefore, the writ petition is premature so far as prayer number B is concerned. In view of such submission, the writ petition is disposed of, giving liberty to the petitioner to seek appropriate remedy in accordance with law whenever the occasion arises. Okay. Yes. Public.
Item 45.
Can you see the last order? Let's see that matter, you will also say that would that the lots of
Yes,
merit apart, you also wanted to know what will be the exact financial implication if your impugned order of the single judge is carried out. So I have taken instruction that it will be about 23,097.
23,000 only.
On principle, we have fine because after the order has run its course,
legal issue will keep it open.
The Land Council for the appellants, Mr. Mishra, on instruction asked for the order dated 21/7/2025, submitted that the amount the department is required to pay is 23,000 and odd. And he has submitted the written instruction to that effect, which is taken on record. In view of such paltry amount, which the appellant's department is required to pay to the opposite party, respondent to the respondent in terms of the order of the land single judge passed on 10/8/2017 in WPC number 1084 of 2011, we are not inclined to interfere with the impugned order. Accordingly, the petition writ appeal stands dismissed. It is open. The legal issues involved are kept open. Yes.
Item 46.
On behalf of the task number, your last occasion, your lordship will directed them to file an affidavit. And also, similar after.
As per the direction matter, that I have already filed affidavit online manner, serving a copy right.
Please go through it, we'll take up. Friday? Any, take instruction next week, anything.
Next week. You have given that?
Yes, my lord. Online I have filed, my lord.
The Land Council for the
hard copy, my lord, I am filing for.
You saw that. The hard copy, just give it.
Lords.
The Land Council for the bank submits the umbrella.
That is not already delivered, what we have confirmed from the postal department also.
The Land Council for the appellants submits that as for the order dated 14/7/2025, an affidavit has already been filed. He gives a hard copy of the same, which is taken on record. Stop. He has also handed over the copy of the affidavit to the Land Council for the opposite party in court today to seek some time to go through the same and to obtain instruction on the affidavit and seeks for an adjournment, put up this matter in the week commencing from 4th August 2020.
May I prevent 11th, my lord?
Okay, on
11th, my lord. My lord, interim order maybe.
Interim order there.
Lord,
interim order dated
interim order, my lord.
2/2020. Which will continue till next day. Yes,
Oblate.
Yeah.
Item 47.
Your lordship can have a look to, just a minute. I'm not disputing anything. Your lordship may have a look to the order passed on 12th of April 2023. The coordinate bench has passed this order. 12th of order number 11, 12th of April 2023. Thereafter, this Honorable Court passed order on 21st of 11/2024, order number 12. Order number 13, your lordship gave me liberty to go through that and give whether the calculation is wrong or right. I concede to the calculation given by the central government that order may be passed. Whatever they say, they admit everything what I have said. Only what they say. Just a minute.
is not the case.
I'm placing the affidavit.
I beg your pardon, with due respect to.
Why are you not, we are not referring the matter to the mediation? This is some amount is to be paid.
That the question is not that exactly in the previous case that Mr. My learned senior Mr. Anand.
You made the calculation.
The question
He
is,
agreed to the calculation.
Let me.
Now, what is the problem?
May I pray, your lordship? As the Honorable Court has observed in this application, if it would be allowed for the benefit, under the impression of the Honorable Court on that date, the amount could have been very minimum. It is more than 25 lakhs, my lord.
That is my
and no, not at all. We are questioning the supervision of the petitioner under rule 5.30 of the Sub-Municipal Regulation, my lord, where it is a parameter to the compulsory determinant of a service code of
the order is like this. Let us be clear.
My lord.
12/4/2023 order. So, consequently, all that is to be examined at this stage is the consequential benefit that the respondent would be entitled to if the impugned order of the land and single judge were to be implemented. Right? So, you have calculated the amount that he says that, okay, it's now you are again going back on the ground that he is not entitled to that.
Yes, madam.
That is why we are referring, we intend to refer the matter to the mediation. What is the problem?
Because in fact, we have, he has been superannuated on the ground that as a compulsory determinant, as a parameter to the 71 of the rules service code. There, he has continued in the service till 55 years, my lord. There is, when the assessment has been made as per the rules, the continuance of the petitioner thereafter depend upon the subjecting satisfaction of the appropriate authority, my lord. While considering his case after his service of 55 years, it is communicated to him that your service should not be extended from that period, and that has been assured in the writ application.
Yeah, that's right, but from 2023 onwards, the exercise of calculation, recalculation, everything is going on,
my lord,
which is reflecting in the orders.
My lord.
And now last order was he sought the time to get instruction whether he is agreeable to the calculation or not. Today he comes and says that yes, I am agreeable. Now you go back.
Because
2022 petition now. All this exercise from 2023 onwards is going on.
My lord, I gave a
calculation,
both the calculation tell each. So I agree for that.
No, it's all right.
This is the...
In fact, no adjudication so far as the merit is concerned, madam. My respectable submission would be the learned court on that under the impression that the amount will be small, that has been direction has been issued. That has not been dealt with so far as the merit is concerned, madam.
Merit, the land and single judge,
my lord,
has written a 17-page judgment, and ultimately the conclusion is that the action of the opposite party in not extending the service of the petitioner,
my lord,
as hostel superintendent in the Sainik school beyond 55 years of age cannot be sustained in the eye of law, and was the office memorandum, and further held that the petitioner is to continue in his service subject to compliance of the so and so. So by the time this writ appeal was taken off by the division bench, he had already passed that age. That is how the London Division Bench passed the order that you just calculate it, that it would have continued up to 60, what would be the financial benefit would have received. And according to calculated and gave it, he agreed now. Now you are going again back, as my esteemed brother pointed out, to prior to 22, whatever there again you are. So.
My respective submission would be, my lord, the order passed by the.
What would be the age of the petitioner now?
My lord, now the age will be.
Because 2010, the writ petition mentioned it is 54 years. So now, if we add 15 to it, then it becomes 69 or 70. So 70-year man is to get this benefit, and he was the hostel superintendent of your organization, worked for so many years. So in the last days, give that. Why are you insisting on?
Madam, the question regarding that compulsory requirement is given, that is the correct or not, madam. And what error in the part of the honorable single judge is that, madam, while considering that we have specifically avoided in our counter affidavit, the number of communication has been made regarding adverse entry in the career. But while mentioning in the order sheet and the judgment itself, that has not been reflected, and only on the ground that has been interfered, because the adverse entry in the
the man has retired, the honorable judge has retired. Let us give respect to the order. Think of something so fight with the man was.
The adverse entries were communicated.
Madam.
Adverse
Yes,
entries were
madam. That is the reason we have subsequently filed to. Your lordship may kindly see.
All discussions have been made. It's not that it's a cryptic order. The reasoning has been assigned.
The finding of
findings of fact. Now, so.
The single judge says that it was not communicated.
Well, that is the reason we have filed with memo, flag E and flag C, your lordship may kindly see.
Was it there before the honorable single judge?
Yes, madam, that record has been produced while passing this order, ma'am. Your lordship knows that so far as compulsory retirement is not a punishment, it is not stigmatic. And there is a adverse entry so far as entire career of the petitioner. That is the reason, and so far as the petitioner, so far as opposite party is concerned, he has served as a hostel superintendent. Due to the lack of discipline and everything, your lordship knows, so far the Sahoo society is concerned, the paramount consideration is the discipline, and to the students should be learn the discipline from the superintendent of hostel manner. He is alleged and taken to custody in the police station for alleged fraud on the part of to giving some appointment to somebody.
And that ultimately acquitted.
Yes, acquittal doesn't mean that we are not giving punishment. We are giving, you also may kindly see that that document is enclosed. He is arrested, has not communicated to the principal. Police officer intimated to the principal that he has been arrested, taken to custody. It is the duty as per the Sahoo society rules that he should communicate immediately regarding his arrest.
This particular observation which has been made by the London single judge, that nothing adverse has been communicated against the petitioner in the name of annual review of performance and health by the principal and medical officer respectively, but the impugned office memorandum retiring the petitioner has been issued on attaining the age of 55 years. So, is there any dispute that if any adverse entry is made in the annual review against a particular person, against a particular employee, whether it is required to be communicated to him or not?
Yes, madam, that has been communicated.
Where is your counter affidavit?
Come to page 10 of the MP note. It records. It says on the query being made by the court. Whether such performance report has ever been communicated to the petitioner, Mr. A.K. Bose, Assistant Solicitor General appearing for the Union of India, contended that the same has been mentioned in the counter affidavit. As such, no communication has been made to the petitioner.
With due respect, you will kindly see the separa the counter that has been quoted by the.
Then you should have filed a review.
You lordship may kindly see it.
You should have filed a review. It is apparent error on the face of record. Where is the question of appeal here?
Your lordship may kindly see the para 6.
Maybe you are correct. Maybe you are correct, but it is a case of review. You should have filed a review. Where is the appeal then?
Even if the review which mentioned also appeal can also be entered.
When the
Apparent
thing
error.
is in the phrase in the mind of the court and you see that something has been wrongly mentioned, is it not your duty to bring it to the notice of the same bench that, sir, you have mentioned it wrongly? We have not made such a submission.
No. I'm not telling that I am not
You are
commission.
you are mentioning that the learned judge has mentioned wrongly in the.
No. I am not. Your lordship may the contention of Mr. Bose is that has reflected in the counter. Your lordship may what is the counter has been reflected. That I have an error on the pass of the record. Your lordship may kindly see that.
You might be mentioning something, Mr. Counsel, you might be mentioning something in your counter affidavit. When it was asked to you in open court, the order was passed in open court.
No, my lord, the judgment reserved.
Okay, it's all right. But when you are mentioning open court, you have made a statement. The honorable judge might have taken note of it, and on that basis of your statement has passed the order.
Council statement of the Union of India is that as per the counter affidavit, you lordship may kindly see para 6. That the appointment may be para and denied by the opposite party.
Please,
you lordship may kindly see
the being made by the court whether such performance report has been communicated to the petitioner. Mr. A.K. Bose, London Assistant Solicitor General appearing for the Union of India, contended that the same has been mentioned in the counter affidavit and as such no communication has been made to the petitioner. Your counsel is making a submission that no communication has been made to the petitioner. You might have mentioned
that is the I bring to that.
Then you should have filed a review.
You kindly my counter affidavit para 6. What has been quoted by the learned single judge. Your lordship may kindly see that the affirmation and para 4 is incorrect and denied by the opposite party. The records of the petitioner maintained in the Sahoo School, Bhubaneswar, reveals that during his tenure as hostel superintendent, he was served with advisory note, counseling note, warning, etc. in indisciplined activities, declaration of duty and doubtful integrity, lack of sincerity and a deviation towards the duty. In this context, it would be worth mentioning here that the chairman local board of administration, Sahoo School, Bhubaneswar, who is the authority.
Have you filed a single document to substantiate this averment taken in the counter affidavit that this has been communicated? So you will not file any document. When a case will be argued, you will argue something else. Now you are coming before in the
record, my lord, that has been produced before the court. That has been reflected in the. You lordship may kindly see original record has been produced. That is the reason why we have given all this document that
the best thing is you go to mediation and settle it. There's a matter many
but fact remains, my lord, that order
that judgment beyond 3 years you will not get. It is 5 years less.
So let us
recovery of settling 3 years.
In view of the so and so mediation because the format mediation.
Try and see.
It's
a matter of.
But that observation.
Rest of the matter will take up on Friday.
Pardon to mention that the appellant is custody since last 15 years, my lord. Pardon to mention, your lordship. Item 51, your lordship, and today's place, your lordship. We have filed a IA for interim bail, your lordship, on the ground of petition of sister's marriage, which is scheduled to the day after tomorrow, 1st August. It may be taken up to item 41.
Okay.
But may I please, your lordship? The petitioner has more than since 10 years jail in. So another is, sir, for bail on parity on the main accused is already.
Pardon to mention, the appellant is in custody for more than 11 years. In another case, it was more than 2 years, but he was on bail during the time. Okay.
Supplemental list, item number 1.
Life imprisonment,
Like a 302.
delayed condoned, admit, then one list to a seat, I will engage further. You want to criminal practice. But
Single bench Mishra କରି
ଅପରାଧୀର ଅଛି ଲିଷ୍ଟ ରଖିଥିବେ ଏଇଟା ତାର ତମ ପାଖରେ ଅଛି ଏଠି କପି ଅଛି ଆଚ୍ଛା ଅଛି ଓକେ ନେକ୍ସଟ
Item 2.
ଏଇଟା ବି ସେଇ
Two like.
ଏଇଟା ଖାଲି ଆଡମିଟ କରି ଏନଗେଜ କରୁଛନ୍ତି Sure.
98 so petition pending was your.
Yes.
Item 3.
Copies of the judgment.
So you take instruction. It is a appeal of the year 1998. नहीं सी आने को जो काको दिया ही थी वो काले जो रेमिशन करेगी छाड़ दिए
हाँ फिर भी बोल रहे हैं टाइप फोटो कोडिंग डालेंगे तो so that we can appoint MITS Korean petitioner.
लेटर फर्स्ट स्टेज है छाड़ दिए तो आओ फिर डिस्पोज ऑफ
Let him get it.
This criminal appeal has been filed by petitioners Mishra, challenging the judgment and provocated so-and-so, passed by so-and-so and so-and-so, in convicting him under so-and-so and sentencing him so-and-so. The matter is listed for the first time. Late the Learned Counsel for the state obtained instruction from the concerned jail authority regarding the well-being of the petitioner and also whether the petitioner has been released prematurely. Stop. the, since nobody appears for the appellant, the phrase wakalatnama is to be obtained in case the petitioner is alive and he has not been prematurely released by the learning council for the state, so that the council from the High Court Legal Services Authority can be engaged to conduct this criminal appeal, to pursue this criminal appeal. A free copy of the order be handed over to the learning council for the state. Matter be placed in the week commencing from 11th of August. By the way, in which jail he was there? Wakalatnama was signed from Balangir jail, actually. Ask someone, we are just passing the order. If someone is available, ask the jail, concerned jail superintendent of Balangir jail to join us. No. Why nobody is there with you? Where is the other council, state council? How you communicate now?
Balangir jail superintendent asked him to.
Yeah. Better occupancy. Yes, next.
Item 4.
Same. Because not your.
Life condition. Life. The same order original lecture, Kali later Pujan, Wakalatnama, Circle Jail, Sambalpur. Sambalpur, Superintendent Sambal. It is mentioned for the law. Itala Balangir, Itala Sambalpur.
Balangir for Sambalpur.
Sambalpur. Second, 4 number Sambalpur. 5 3 number হচ্ছে বলাঙ্গীর হ্যাঁ সে লক্ষ্য যদি থিব তা সহিত এটি আপিয়ার করিয়া পড়ে তারপরে
Item 5.
এইটা ওটা কোনো এটি আসছি ক্রিমিনাল আপিল লেখা 28 of 2022. Against the family court order, it has found. That is a appeal under section 19 of this one. এটি কোন এই appealটা আমি assignment দেখিও family court order against the criminal appeal carrying provision. Assignment ଅଛି list ଦେଇଥିଲେ କଣ ଏଟା family court order against the foot ଯାଉଛି ଆମର ତ ନାହିଁ ଏଟା criminal only against conviction only. Criminal appeal so and so. MP MLA, death sentence, family court order against family court. At a division bench from section 19 appeal to division bench hearing over the family court act approach. Family court act देखिए Section 19, the CORAM. Right, Indian Constitution. Right? Section 19. Six subsections. Section 99.
Section 96 bar marriage. Both है
Report on the census shall be held by a bench consisting of two or more.
No, it's the arranging of 125 everybody.
এটা তো করে না এটা 125 তো The High Court may on its own motion authorize call for examining the record of any proceeding with the family court situated within some passed an order under Chai 125 for the purpose of satisfying Shamsu, not being an interlocutory order as to the regularity of this proceeding. এইটার প্রতি revision লাইক করিব এইটার প্রতি appeal করিব appeal against any order.
Pending debate is not closed, it can be dismissed for non-proceedings. আমার assignment of
नहीं इतने assignment नहीं तो पटरी तो बता
we should be for assignment.
This criminal appeal has been filed by appellant Khetravashi Naik under section 19 of the Family Court Act 1984, challenging the order dated 16/1/2002 passed by the Lion Judge Family Court Qatar in criminal proceeding number 20 of 1998. In a proceeding under section 125 CRPC filed by the respondent and directing the appellant to pay monthly maintenance at the rate of ₹350.
No, see also well.
With effect from the date of application, that is 12/1/1998. Dismiss
see also well.
And none appears for the appellant. The criminal appeal stands dismissed for non-proceeding. Yes.
Item 6.
For the appellant, but the registry has marked out some defects. It has come straight after a long time. It has not been admitted yet. Lordship may afford me some time to clear the defects and still.
After 2 decades, you
Okay,
realize that.
Ask the Puri jail superintendent to appear. Same order for the Puri jail superintendent. You wait. Puri jail. Balangir, Sambalpur, Puri. Now what if you do? Come quite say local jet. You wait, that land may appear to. Next.
Item 7.
May please, Lordship. Well, I pray for 1 day time to verify matter. Perhaps my knowledge is concerned. This appellant have preferred two different appeals. Two different appeals. Other defect initiative nahi. I will verify from the office. Otherwise, I will file a not press petition. Dita hypo I not press korte. Only 1 day time more the office verify kare. For same appellant, different appeal filed by me, another advocate.
Since this is pending since 2007. Till date you are not able to.
No, I have already filed a not press memo, but I will only want to verify.
What is that other appeal number?
Other appeal number, my lord, only 1 day, my time. I wanted 1 day time, my lord.
You got nothing less than 15-20 years.
No, my lord, exactly, this is not the matter. Same matter to same, another council file, that's why I'm silent.
Yeah.
Ms. Nando, when counsel for the appellant submits that perhaps the appellant preferred another criminal appeal challenging the self-same judgment and order of conviction passed by the Land Session Judge Kalahandi dated 17/1/2006 in SC case number 6 of 2005, and the matter may be taken up day after tomorrow to obtain instruction. The result of the said criminal appeal, if any, list this matter on 1st of August 2025.
Item 8. Item 9.
Wait.
8.
এটা লেখুন সার্কেল জেল চৌধুরা অর্ডার সেম যাবে নম্বর ওটা কাম সে মিলু আলিয়াস দিবাকর প্রধান নেক্সট
Item 9.
live. Yes, it all Keonjhar, right. Keonjhar. ଆଉ କଣଟା ନା ମାତାବର ପାତ୍ର ହଁ ନେକ୍ସଟ
Item 10.
এটা ଚମ୍ପୁଆ କୁହନ୍ତୁ ନେକ୍ସଟ
Item 11.
ଭୁବନେଶ୍ୱର सब लाइफ इंश्योरेंस What happened over the date, Mansi?
Date I will convey that he has intimated that he cannot appear because a separate panel has been constituted by the Honorable High Court. That's why he's not interested to appear.
Not interested.
That's why he wants.
No. Then you take instruction from the registry.
Well,
that whom he wants to engage, so that it will be reflected in the name. We'll record your submission.
Yes, I had intimated the Registrar General that will convey.
Otherwise, you will pass the order that this is the statement and let the matter come next week. So that a panel, any of
After the panel, remain in place.
That is their outlook. A statement that your petition, your review petition, who will appear, you have to decide. We can't say anything.
If you say that
Advocate General is supposed to appear. If he doesn't want to appear, then you
if
engage
you say
someone.
that any panel counsel lawyer is to appear and that is your instruction, then either you take instruction from the RG,
give
the names, or we can record your submission and place this case on Monday. So that on that day at least.
Let the matter on Monday, so that whatever development in between, I will in consultation with the Registrar General. I'll
Simplicity release it on Monday for orders. This is
the last word on consensus of the parties. Place this matter on 4th of August 2025. And you communicate that to the learning Mr. Rautre and also Mr. Mahanti.
Item 12.
Why is it a bill application? So, Poland has already undergone 41 years of imprisonment.
Just a minute. Already spoke. Flag C and flag D. What about your client, Mr. Mahanti?
He didn't get jail custody.
Have you taken instruction? Or you are thinking that he might be?
No, he was
No,
produced by
because
the last date he was produced by the judge supported by the EC.
Which date?
Last one. please.
Not on 21/7.
Please start.
Appellant was
Your
asked to
lordship has
prepare
also
reflected.
कोई chapter that has it.
Actually,
21.
how many deceased are there in this case?
One deceased, my lord. One knife blow was given. It at best there is no intention. Yes, so the 13 minutes altercation in between and tussle in between the deceased and the present.
21 years, I'm the wrong. 21 years.
21 years in court.
Appeals in your chamber is pending.
Field, my lord. CR for appeals.
No. The most, that 2006 appeals you filed and thereafter you did not even bother to file a memo for
No
listening.
instruction was given by the.
That's right, but
Yeah,
you have filed. See, this man is remain in custody for 21 years.
21 years.
You filed in 2006.
Do you know what statement he made last time? He said that my advocate said that the case is pending. And if this matter would have been admitted in 2006 and would have decided in the meantime since long. Now we are admitting in 2006 criminal appeal live conviction. We are admitting in 2025.
After 20 years, just see.
I could not violate.
वैसे दीजों को डॉका से जो हमको डॉक्यूले टिके बोले थे शिव इन खाली रिपोर्ट दे देगी से अभिषेक विश्वाल डीलिंग असिस्टेंट और से जो कौन था गोवर्धन मुदुल से दीजों जाओ डॉका Miss case number so and so, this is an application for a IN number so and so. This is an application for bail. After hearing the land council for the land council for the state has produced the custody certificate of the petitioner, which indicates that he is in from Superintendent District Jail Tenkana. Is custody more than 21 years. The custody certificate is taken under court. Strong. After hearing the land council for the respective parties and going through the impugned judgment, and since it appears that during course of quarrel, the appellant stated to have dealt a single knife blow with the deceased, which resulted in his death and was taken into account the period of detention. We are inclined to release the petitioner on the sterilization of time.
No intention.
Hearing us. This case was filed in the year 2006. But we have reflected in the order dated 21/7/2023 that it was not listed in for admission for 19 years. Yearly in the ground that there was some different minor difference. And we also asked the national dealing assistant and the section officer to submit the report with explanation to why there was non-immediate in the listing of the matter. The Mishra Vishwa, the one who dealing assistant, submitted his explanation that Fortunately, I had filed it, my lord, because they have thrown the file and point out. They did not.
Find out if any such old appeals are pending in your chamber and see that what is the status of those cases. Yes, next.
Item 13.
Delete the bail.
We have granted bail and fine has been stayed. Okay.
CA is a receipt and criminal application and receipt. So here is a flag C make and a glance. The petition filed by the daughter, present appellant, to release the deposited amount with a condition imposed by the release on bail. 1 lakh was deposited in cumulative fixed deposit. Now,
Just a minute. Let us go through the order dated 16/7/25. Please read it out.
National Court the order dated 16/7/2025 held that this interim application has been filed by the daughter of the appellant, namely Pratyasha Patnaik, to prayer to pass appropriate order for release of the deposited amount of rupees 1 lakh with accrued interest in her favor. Learned counsel for the petitioner submits that by the order dated 28/9/2011 passed in miscase number 1326 of 2009, the appellant was directed to be released on bail inter alia with a condition that he shall deposit a sum of rupees 1 lakh in the name of his daughter in any nationalized bank or post office for a period of 6.5 years with a renewal clause for another equivalent term, and furnish the gas certificate within bracket postal certificate or term deposit certificate bracket close before the trial court with an undertaking that he shall not mortgage or pledge the same, and the learned trial court shall intimate the same to the post office or the bank as the case may be. Accordingly, learned counsel further submits that in pursuance of such order, the appellant deposited a sum of rupees 1 lakh and he was released from custody, and at this juncture, the daughter of the appellant, who is the petitioner in this interim application, is in need of money. Not only she has attained majority and completed her +2 course, but also she is interested to prosecute higher studies in BSc nursing course. And she does not have sufficient property or source of income, and therefore, in order to fulfill her ambition of prosecuting higher studies, the money so deposited as per the order of this court dated 28/9/2011 by the appellant may be released in her favor. When counsel further submits that the appellant Sagar Patnaik alias Shivashankar Patnaik is now staying with the petitioner at Bandhanayagara under Chandpur police station in the district of Nayagara. Let a copy of the interim application be served on the learned counsel for the appellant, so also learned counsel for the state, who shall obtain instruction through the inspector in charge of the Chandpur police station.
You are for the?
I am for the daughter, madam.
Okay.
And I have
So have you served a copy?
Yes, yes.
Both
We have received, I have also communicated to the IAC.
Hmm.
He has to suffer some time at least
Who
one.
is appearing for the informant? Sorry, appellant.
Your Lordship, I am appearing on behalf of S. Ratha as appellant. Your
You are appearing for?
Appellant on behalf of Mr. S. Ratha, Your Lordship.
A. Das.
S. Ratha, Your Lordship.
S. Rotho. Okay. Yes. Marking. S. Rotho, yes.
See, he cannot appear now. Sanjay Rath. Sanjay Rath. Sanjay Rath may not because he is in the panel.
Panel. So the intimation has to be given to the appellant, because if the no one is there in the to appear, then because it is he who has deposited that amount of rupees 1 lakh. Now the daughter is coming forward to asking to release that amount. So obviously
the Sagar Patnaik is required to be heard in this matter, the appellant who has deposited the money. So,
That was the condition while granting bail.
that was a
For the
condition.
well-being of the
But
child.
again, it may be that
But from the
better.
condition, this condition only imposed to keeping in view the welfare of the child, because the mother of the child was died and the father is the convict.
No, behind his back, it would not be proper. That is why we just want to. Why don't you take steps?
My lord, I have already.
No. The council are now, you know the problem of the.
My lord.
They are now in the state
My
panel.
instruction is, my lord, the appellant instructed the council engaged by him and the police, local police.
You send one thing can be done. You give a copy of the interim application to the London Council for the state. He will forward it to the IAC.
Yes, I have.
Then we have received. We have received and also communicated.
Communicated to whom?
To the IAC. That he has sought for
And
time to
IAC also.
No, serve a copy of this interim application on the appellant who has deposited. That what we want.
To jailer will.
So that we can fix a date.
Okay.
So the problem will be that now nobody is there to represent him. On the last order we have mentioned none. So IA number 1817 of 2025. The London Council for the petitioner of this IA submits that as per the order dated 16/7/2025, he has served a copy of the interim application on the London Council for the state. London Council for the state submits that after receiving the copy of the interim application, he has sought for instruction from the concerned IAC. Since no one is appearing for the appellant, let another copy of the interim application be handed over to the London Council for the state, who will send the same to the inspector in charge of which police station it is?
Chandpur police station.
Chandpur police station. But the appellant's house is at Chandpur.
My lord, last order you also.
Nuapada lekha.
My lord, that is permanent address. Now they are staying at Kandha Noyagada under Chandpur police station.
Last part of the third para.
Chandpur police station is Chandpur कोर्ट से रोज केम जानिबे से
already visited their house.
Oh, to the inspector in charge of Chandpur police station for its service on the appellant, and it will be intimated to him that no one is appearing for him in the High Court and is free to engage any counsel of his own choice. And if he has got any financial difficulty, a counsel from the legal aid panel, High Court legal aid committee, can also be engaged for him. And if he is interested for the engagement of a counsel from the legal aid panel, signature in the Wakalatnama shall be collected by the IAC and it can be sent to the Land Council for the state. Put out this matter in the week commencing from, you get it by 11th, list this matter in the week commencing from 11th of August 2020. Yes.
K making the class, the premature release, plug K.
Premature release.
ପଳେଇଲା ରିଲିଜ ହେଇଯାଇଛି
ଆଜ୍ଞା।
ସମୟ
କଣ
ପୂର୍ବରୁ
କଲେ
ଖଲାସ
ପଡିବ ସମୟ ଆଚ୍ଛା ସମୟ
ଦ୍ୱାରା
ପୂର୍ବରୁ
ପୂର୍ବରୁ ସୂଚିତ କରାଯାଇ
Right.
ଓଡ଼ିଶା ସରକାର ମହାନିର୍ଦ୍ଦେଶ ତଥା ସାଧାରଣ ସେବାଙ୍କ ସରକାରୀ ଆଦେଶ ସଚାଂଶ 21/7/15 ତୁମକୁ ସମୟ ପୂର୍ବରୁ ଖଲାସ କରିଦିଆଗଲା। ଏ ତୁମର କହୁଛନ୍ତି ଜଣାଇ ଦିଆଗଲା।
ଠିକ ଅଛି 11 peruse the report furnished by superintendent senior superintendent এটা কোন এটা মন্ডল কারাগার মানে
Circle jail, Berhampur.
Circle jail, Berhampur. Wherein it is indicated that the appellant has been released prematurely by order dated 1/1/674 dated 21/7/2015. In view of such written instruction received, the jail criminal appeal is disposed of. Hello. Next.
Item 15.
May I please, Your Lordship? Item 15, Your Lordship, last occasion the custodial certificate has been called for.
For that, it may take some time because altogether 13 or 15 cases are pending. So they are verifying for more antecedent exactly present appellants. So I pray for 1 week time.
No, so far my knowledge is concerned, Your Lordship, I have only 2-3. Let them supply the antecedents so that I will file an affidavit.
Reflected in the impugned order.
Okay. The Learning Council for the state seeks some more time to not only to produce the custody certificate, but also to obtain instructions relating to criminal antecedents, if any, against the petitioners. Put up this matter in the commencing from 11th August 2025.
The details of the number, Your Lordship, can you furnish to me so that I can also.
Furnish by next day.
Oblige, Your Lordship.
8 and you. You will be mature release.
I am custody since 18 years, Your Lordship. A short date may can fix so that.
11 তারিখ রয়েছে
Oblige, Your Lordship.
Item 16.
May it please hear. Item number 16, my lord. In this appeal, 2 appellants are there, my lord. Both are lady. They are in judicial custody since 31st May 2030. Was ordered at 29th October 2024. The release on interim bail for a period of 3 months. In the surrender, Your Lordship. The surrender certificate is at flag J, my lord. Flag J.
Just a minute. এই গোটি কেস তো বারকোড পিএস কেস নম্বর 77 মানে ডিউ থ্রু এ কনভিকশন আরাইজেস করছিল
আଜ୍ଞା
ହଁ সেটা ଆଉ କିଛି ନାହିଁ ବାକି not involved in any other case. Last time जो हमें interim bill देखलो केबे?
That is 29 October 2024.
29 October 2020.
24.
Lady return. They are the Land Council for the petition, Land Council for the state. The Land Council for the state has produced written instruction dated 17/7/2024 from IIC Barford Police Station, which shows that there is no other criminal antecedent against the petition. On the last date, the Land Council for the state has produced the written instruction received from Inspector in charge of Barcode Police Station that no adverse report is there against the petitioners during the period of interim bail. And they have not flouted the terms and condition of the interim bail order. And they surrendered before the London trial on 4/2/2025. And they are now in jail custody at a special sub-jail, Devgarh. While granting bail to the two petitioners who are ladies as per order dated 29/10/2024 in this case number 1722 of 2016, we took into account the period of detention of the petitioners in judicial custody for more than 12 years, and that the paper book has not been prepared. Considering the submission made by the Land Council for the petitioners, and since the petitioners are ladies and they have not flouted the terms and condition of the interim bail order, keeping in view the principle laid down by this court in the case of Leti alias Jayadev Rai, we are inclined to release the petitioners on bail allowed.
Item 17.
This is an application for bail bills. The petitioner has been convicted bills for life for offense punishment under section 302 and other offenses bills.
You have filed only for appellant number 6.
Bills. Bhagavan Orissa.
What about the other appellants?
Bills overall religion bail bills.
Your bail application was earlier rejected.
Yeah.
By which order?
Yes, it was rejected bills in the year 2016 bills.
Just tell us how many times it was rejected.
One time bills.
And that is in the year 2016.
Bills.
Can you tell us the date of the order of rejection?
So please.
No, in that order, not only appellant number 5, but 6, 7, 13, 14.
Bills.
Those were rejected.
Bills.
Subsequently, some have released.
Thereafter, others have been released.
That 6, 7, 13 and 14 have been released on.
Bills.
6 and 14 पुनी 5 न 17 रिजेक्ट ହେଇଛି.
ତାପରେ ଆଉ 7 ଆଉ 13
7 was granted bail lastly on 14 allow ହେଲା 21/4/2023. 7 was granted bail on 12/3/2023.
अब ये कितने वर्ष रहलानी?
Bills since 2016 losses.
2016
bills. 24/6/2016.
24 to 2016.
24/6 bills.
24/6/2016.
Bills.
No, that may be during pendency of the appeal. We are asking you about the period of detention from the during trial. You are on bail or you?
Well, she was on bail bills.
Okay. So the name of the appellant number 5 is Bhagavan Orissa.
Orissa bills.
So Mr. Mahanti, the 4 persons were segregated when bail was granted. So now out of them 3 have been gone on bail. So let him go.
Earlier, initially, by common order of this one rejected.
Now the London Council for this bail application has been filed by the appellant number 5 Bhagavan Orissa. The Land Council for the petitioner submit that the petitioner was on bail during trial, and after the pronouncement of the judgment by the London Trial Court on 24/6/2016, he has again been taken into judicial custody. He further submits that the bail application of the petitioner, along with the co-appellants, Bhagwan Arishal, appellant number 6, Bhagirathi Juhar Singh, appellant number 7, Deepu Sundar Roy, appellant number 13, and Ravi Sundar Roy, appellant number 14, were rejected. He further submits that in the meantime, while granting bail to the other appellants, he further submits that in the meantime, appellant number 6, 7, 13, and 14 have already been granted bail by different orders of this court, which is not disputed by the Learned Counsel for the state. Mr. Manti, we are recording your statement.
Only there 6 and 14 rejected on 5/4/2017.
बेल आपको पचारुछु पुरा रिजेक्ट तो हेची समस्त पांच जनकर रिजेक्ट हेची अन्य मानकु बेल दिया हेची आपन को हमें सेहित पई कहलु जे
21/4 सोफार दी रेकर्ड 21/4/23 रे
टिके रो 21/4/23
रे
हां कार बेल होला
14
ये 14 ग्रांटेड बेल अच्छा
और 12/5/2023 ये 2023
12/5/2023 रे
7 appellant number 7
ग्रांटेड बेल तापरे अब बाकी दीटा रहले 6 नंबर और 13 नंबर 6 नंबर नाला भगवान हरिशाल 13 नंबर नाला दीपू सुंदर राय.
the order sheet as reflected in the outcome doesn't reflect in about other sheet. That's why
Mr. Puspala, can you tell me the date on which they were directed to be released on bail?
Yes, exact date I have not mentioned, Millers, but my
You are the counsel for all the appellant.
Millers.
A7, you are right on 12/5/23.
17/1/20 17.
17?
117, right? Appellant 5 day.
Yes, 17.
117.
17 5 and 13
5 और 13.
Just 17 में 5 13 हो गया सब 5 को दिया यही चीज देन 5 पुणी कोण आछला এটা কি আকার
You are 6 na?
Yes, sir. Bhagwan or Isal?
No, you are application, you are 6 na? 6 is 6.
Bhagwan is 6.
अच्छा 6 sir.
It's coming from.
তারপরে এটা হলো তাহলে 17/1 2017 রে তাহলে আচ্ছা appellant number 5 और appellant number 13 है ना ये जो लिखा है ना तो से ठीक मान लिखने से लास्ट सेंटेंस अपन हाँ हाँ ठीक है थोड़ा सुन नहीं 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 मुड़ल पढ़न दो से जो कि डाक्टर सबमिशन This is an application for bail filed by
Bhagwan or Isal? Bhagwan or Isal?
appellant number
6.
6. This is appellant number 6. You filed the interim application appellant number 6. So, the order देखिए जो order rejection is ना लगे rejection এটা হলো ভগবান আরিসাল বেল অ্যাপ্লিকেশন
তারপরে again on 5 और 4 17 6 and 14 rejected. Again, second time.
लिखिन ना the bail application of the petitioner है ना along with the bail of appellant number 5 Babu alias Satish Arishal, appellant number 7 Bhagirathi Jujar Singh, appellant number 13 Deepu Sundar Roy, and appellant number 14 Robbie Sundar Rai were rejected. He further submits that as for order dated 17/1/2017, the bail application of appellant number 5, Babu alias Satish Orissa, and appellant number 13, Dipu Sundar Rai, were allowed. Was allowed. Similarly, as per order dated 21/4/2023, the bail application of appellant number 14, Robbie Sundar Rai, was allowed. And as per order dated 12/5/2023, the bail application of appellant number 7, Bhagirathi Vijhar Singh, was allowed. And since the petitioner stands on this similar footing and he is in judicial custody for more than 9 years, and there is no chance of early hearing of the criminal appeal in the near future, the bail application may be favorably considered. Upper Lecturer and Counsel for the state has not disputed about the release of the two appellants whose bail application, along with the petitioner, were rejected by the order dated 27/9/2016. Considering the submission made by the Land Council for the respective parties, the period of detention of the petitioner in judicial custody, the release of the two appellants on bail, similarly situated two appellants on bail, we are inclined to reconsider the prayer for bail and direct the petitioners to be released on bail. Yes. And there is an application for stay of realization of fine that is allowed.
Item 18.
The jail superintendent Manu kuhaiji to won't to sigra appear karibe. Next, item 18.
May I please, sir? That flag D and email the petition has come from the jail engaging as a counsel.
Have you filed your wakalatnama?
Yes, sir. It is in the records.
Prisoner's petition for both the appellants. These appellants have been received from jail, which are at flag D and E for engagement of Mr. P.B. Rautrai as their advocate. Mr. Rautrai has filed wakalatnama. Wakalatnama that is the killer. Filed wakalatnama for both the appellants, which is accepted, except the name of Mr. B.B. Rautrai. The names of other counsel shall not be reflected in the cause list henceforth. Yes, you have filed an application for bail.
Yes, sir.
Agu rejected la?
Yes, sir.
Kebe?
24/7/24. In IN number 1755 of 22. Who custody more than 14 years in that.
ବର୍ଷ ତଳେ ରିଜେକ୍ଟ ହେଇଛି ଆଉ କିଛି ଦିନ ଯାଉ ଦୁର୍ଗା ପୂଜା ପରେ।
Item 19.
May I please, Your Lord? My Lord, here I filed my wakalatnama with there is a consent from the earlier counsel. And I filed an IA for interim bail. I filed the bail for bail.
No, how many appellants are there?
2 appellants, man.
So you are appearing for whom?
Only appellant number 2, man.
The bail application of appellant number 2, whether it was earlier rejected?
Yes, ma'am.
By which order?
By order dated 16/8/2019
EW 3 and 4, the eyewitnesses to the occurrence, so on so forth. କେତେ ବର୍ଷ ରହିଲେଣି?
ରହିଲେଣି 23/12/2015
ଟୋଟାଲ କେତେ ବର୍ଷ ନା
10 years my lord.
ଅଛି କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ମଗେଇ ଦିଅନ୍ତୁ ଆଉ କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟସ୍ ଆଣିବୁ ଆଉ କଣ୍ଡକ୍ଟ ଅଫ ଦି ଜେଲ କଣ୍ଡକ୍ଟ ଆଣିବୁ ଲେଖନ୍ତୁ IA number 2035 of 2025. This is an application for bail of appellant number 2, Syria alias Sridhara Pradhan. The learned counsel for the state seeks some time to produce the custody certificate, and to obtain instruction regarding the criminal antecedents, if any, against the petitioner, so also his jail conduct. Put up this matter in the week commencing 11 तारीख रे रखुछु 11/8/2025 କୋଉ ଜେଲ ଅଛି
ଏଟା ଆଜ୍ଞା ଢେଙ୍କାନାଳ ଜେଲ
ଦେଖି ଦିଅନ୍ତୁ ଢେଙ୍କାନାଳ ସେ ଜେଲ ଆସିଲାଣି କି କେତେ ନମ୍ବର ସିଏ ତ ଯୋଉଟା ଆସିଛି ତ ମ୍ୟାଟର ଲଗେଇ ଦିଅ 11 ନମ୍ବର ଫାଇଲ ଦିଅ item 11.
Pass over item number 11.
କୁହନ୍ତୁ ସେ କିଏ ଅଛନ୍ତି ସେ ସୁପରିଟେଣ୍ଡେଣ୍ଟ କିଏ ଅଛନ୍ତି ଆଉ ତାଙ୍କୁ କୁହନ୍ତୁ ସେ ଯୋଉ ସେ ଲୋକଟାକୁ ଆଣିବେ ସାମ୍ନାକୁ ତା ନାଁ ହଉଛି ପାସୁଆ alias ପ୍ରଶାନ୍ତ କୁମାର ମୁଦୁଲି ଝାରପଡା ଜେଲ ଝାରପଡା ଜେଲରେ କିଏ ଅଛନ୍ତି
Item 20.
May I please?
9th July, stop for custody certificate and criminal antecedent of the appellant.
With 3% time.
Ask the person who will appear, he should be in proper uniform also. Hello? Item 20 कौन है ना?
They pray 1 week time. To obtain instruction is referral sent. 14/7.
कौन इंस्ट्रक्शन में होगा?
Criminal antecedent and
custody certificate. अच्छा, लिखो देता. Item number 20 and IA number 1945 of 2023. The Learned Counsel for the state seeks some more time to obtain instruction as per the order dated 9/7/2025. Put up this matter in the week commencing from 11/8 roila 11/8/2025. Yes.
Item 21.
May I please, Sir, my lord, last occasion your lordship called for the custody certificate and the jail behavior.
Sir, patient and bonus.
No.
नमस्कार
ଏଇଟା କଷ୍ଟ ସେଟଲମେଣ୍ଟ ମୋ ପାଖରେ ଗୋଟେ ଜେରକ୍ସ ଥିଲା। ଆଉ ଗୋଟେ ମୁଁ ଦେଖ
Custody certificate କାଇଁ?
ମୁଁ
ତା ନାଁ ହେଲା ଏମ୍ ଉଦୟ କୁମାର।
ଆଜ୍ଞା ଏମ୍ ମୁଁ ଦେଖ
ହଁ। ଏମ୍ ଉଦୟ କୁମାର ଦେଖଉଛି 9 ବର୍ଷ 5 ମାସ, ରାଇଟ୍? ଆଉ ବାକି ଆଉ କିଛି କେସ୍ ବାସ୍
ନାଇଁ କିଛି କେସ୍ ନାହିଁ। ଆଉ ଏବେ ବି ମଧ୍ୟ ଜେଲରେ ତାର ସାର୍ଟିଫିକେଟ ମିଳୁଛି, ଭଲ ଅଛି। ପାରାଗ୍ରାଫ 7 ରେ ବି ସେ ଲେଖିକି ଦେଇ
ଇଏ ଗୋଟେ କଣ ସ୍କୁଲ ଟିଚର ଭିତରେ ଥିଲା?
ଆଜ୍ଞା ଆଜ୍ଞା teacher is 77. I mean, the forest was suspended. Report was called for as per last year, the status of the teacher. In 17, he was put under suspension. After received the complaint about his arrest. The student is the victim.
ଇଏ ଭେରିଫିକେସନ ହେଇଛି ଆଉ କିଛି କେସ୍ ନାହିଁ ବୋଲି।
ନାଇଁ କିଛି
ଆପଣଙ୍କ ରିଜେକ୍ଟ ହେଇଥିଲା ଆଗରୁ?
ନାଇଁ rejected first.
ମିଷ୍ଟର ମହାନ୍ତି
Hello.
ଆଗରୁ ରିଜେକ୍ଟ ହେଇନି ତ?
ନାଇଁ
ସେ ଝିଅ ବର୍ତ୍ତମାନ କଣ
ନାଇଁ
କରୁଛି?
କୋର୍ଟ ସେ
ପୁଅଟା।
ପ୍ଲସ୍ ପ୍ରୋଗ୍ରାମ ମେଟ୍ରିକ
ସେ କଣ କରୁଛି?
Item 22.
Item 22, last general lordship directed for file comprehensive affidavit, my lord. So the day, my lord, I am filing the comprehensive affidavit, my lord.
Give him a copy, let him verify.
Just now, I am also serving.
While entry bail, he was on parole, he was absconded.
Let's see what he has mentioned in the comprehensive affidavit, take instruction on that.
Yes.
Learn
In one
counsel
case,
for
was
the-
acquitted and other two cases bail and another case till 2013 not
Counsel
remanded.
for the appellant, Mr. Bhondev files the comprehensive affidavit. As per the order dated 24/6/2025 and handed over a copy of the same to the land counsel for the state who seeks some time to the vote to the same foot of this matter on 11th of August 2020.
And custody secretary.
Actually, Acha, in the meantime, the land counsel for the states are also obtained the custody certificate. Yes.
Item 23.
The matter gas. Silagi ja, silag kahiyam. Avion to Puri. Mr. Mahapadra, just wait for a moment. We have called some Puri Aswani. Puri ta join karo. Item number 6.
Puri.
नमस्कार. आपण कौन डेजिग्नेशन कौन?
सब असिस्टेंट जनरल.
अच्छा. ते जने मुद्दाला जा ना होची पासवा उर्फ प्रसन्न कुमार मुदुली जी की एडहॉक एडिशनल सेशन जज फास्ट ट्रैक कोर्ट नंबर 2 भुवनेश्वर रे ट्रायल फेस कला 302 दफारे आउ ताकू 27/1/2010 रे 302 ଦଫାରେ ତାକୁ ଆଜୀବନ କାରାଦଣ୍ଡ ଟ୍ରାଏଲ କୋର୍ଟ ଦେଇଥିଲେ ସେ କ୍ରିମିନାଲ ଅପିଲ ଫାଇଲ କରିଛି ତାର ଏପର୍ଯ୍ୟନ୍ତ ଆଡମିସନ ହେଇନି ତାର କଣ ଷ୍ଟାଟସ କଣ ସେ ଆପିଲାଣ୍ଟର
2018 ମସିହାରେ ସେ ସାଇକେଟ୍ରିଷ୍ଟ ହେଇଥିଲା ଚୌଦ୍ୱାର ଜେଲ ଏବେ ଟ୍ରାନ୍ସଫର ଯାଇଛି
ଆକୁ ଚୌଦ୍ୱାର ଜେଲକୁ ଯାଇ ତାକୁ କହିବେ ସେ ପାଶୁଆ ଓରଫ ପ୍ରସନ୍ନ କୁମାର ମୁଦୁଲିକି ମଧ୍ୟ ଆପିୟର କରେଇବେ ହେଲା এটা হলো চৌদ্বার জেলକୁ ଯାଇଛି ଆଚ୍ଛା ଆଉ କିଏ ଅଛନ୍ତି କି କହିଲେ
In item number 10, the conduct has been released on premature.
10
Has been released premature.
prematurely ଦିଅ yes just item number 10 টা single appellant
Single.
Mahavir আছে
Mahavir.
the land council for the এটা হচ্ছে item number 10 হ্যাঁ criminal appeal number 323 2011 the land council for the state has produced the written instruction received from the DG of Prisons dated such and such so also Deputy Secretary to Government which indicates that the petitioner has been, so the appellant has been released prematurely by the government and government has been pleased to remit the unexpired portion of the sentence and release prematurely. The relevant daters are taken on record. The criminal appeal is disposed of.
Item 4 also.
Just a minute, disposed of.
4.
Data house item.
4 also we are premature.
4 10. इसके ये मारो.
That is
item number 4 भाग.
4 also.
রজনীকান্ত বই
রজনীকান্ত
the land council for the item number 4 CRLA number 213 of 2001 the land council for the appellant has state has produced written instruction received from senior superintendent circle jail Sambalpur wherein it is mentioned that the appellant has been released prematurely by order number 3320 dated 30/3/2017. The written instructions are taken on record. The criminal appeal is disposed of. It has the order number ta photo de se jo purba tar jo bata hai order number or date ta no এটা will be starting for them no ଆଉ ଯୋଉଟା ଆସିବେ ଆପଣ କହିବେ yes next item
Item 23.
Similar. Section has also directed the call for the report. He was released on interim bail. Your lordship directed to obtain the conduct certificate.
mentioned that the anticipating problem. The appellant did not take revenge against the family and objected to the release from bail, but nothing is found mentioned about the conduct of the appellant during the interim bail period, which was granted as per the order number so and so. The report is taken 6 some time. The key on କେବେ ଯାଇଥିଲେ ଆପଣ ଯୋଉ ବେଲ୍ ଟା ଯୋଉ ଇଣ୍ଟରିମ୍ ବେଲ୍
Bail order ହଉଛି dated 1/7/2024.
You are taken into custody on 7/8/2016. You know, how the land and council for the petitioner land council for the state. As for the order dated 23/7/2025, the land council for the state has produced the written instruction received from IIC Balikuda police station to the effect that during the interim bail period, the conduct of the petitioner was good in the locality and also in the native village. The written instruction is taken on record. The petitioner was directed to be released on bail, interim bail, for a period of 3 months, as per order dated 1/7/2024, taking into account his period of detention in judicial custody since 7/8/2016, and also the principle laid down in the case of Leti alias Jayadev Rai and another versus state 1993, so on so. Since the petitioner has not flouted the terms and condition of the interim bail order and absence of any chance of early hearing of the criminal appeal, and further taking into account his period of detention in judicial custody, we are inclined to release the petitioner on bail allowed. Mr. Sorochandra Mahapatra, the senior advocate for the yes.
Item 24.
Please. This is order 6302. Petitioner the lady, which is custody.
Agu reject ହେଇଥିଲା କି? ଆଗରୁ ରିଜେକ୍ଟ ହେଇଥିଲା ଆପଣଙ୍କର ବେଲ୍ ଆପ୍ଲିକେସନ ହେଇନି ଫାର୍ଷ୍ଟ ଟାଇମ୍ ଡିପୋଜିସନ କପି ଅଛି ଆପଣଙ୍କ ପାଖରେ ଦେଉନାହାନ୍ତି ଡିପୋଜିସନ କପି ଲେଖନ୍ତୁ ଆଇଏନ୍ ନମ୍ବର just a minute. କେତେ ଜଣ ଆପ୍ଲାଏଣ୍ଟ ଆଧିରେ ଜଣେ ଦିଟା ବେଲ୍ ଆପ୍ଲିକେସନ କାହିଁ ଫାଇଲ କରିଛନ୍ତି 810/2020 ପୁଣି 1140/2025 ସେମିତି ଷ୍ଟେ ରିଏଲାଇଜେସନ ଅଫ ଫାଇନ୍ ଦିଟା ଆପ୍ଲିକେସନ ଆପଣ ବୋଧେ ସବସିକ୍ୱେଣ୍ଟଲି ଆपिୟର କରିଛନ୍ତି ତ ଅର୍ଲିୟର ଆପଣ ଫାଇଲ କରିଛନ୍ତି 2025 ର ଆପ୍ଲିକେସନ ଅର୍ଲିୟର ଆପ୍ଲିକେସନ ଗୁଡା ନଟ୍ ପ୍ରେସ୍ କରିଦିଅନ୍ତୁ ହେଲା ଆଇଏନ୍ ନମ୍ବର 810 of 2020. This is an application for bail. The Land Council for the appellant that he has filed another application for bail, that is IN number 811 of 2020. He does not want to face this interim application. Accordingly, IN number 810 ta eta disposed of as not placed. Same thing. IN number 811 of 2020 another application filed 1138 of 2025 for stay realization of fine ତେଣୁ ସେଟା ହଉଛି not place ବାକି जो order ଲେଖନ୍ତୁ IN number 1140 of 2025. This is an application for bail. Land and Council for the state submits that he is not having the deposition copies. Let the Land and Council for the appellant supply the deposition copies to the Land and Council for the state. Kebe debe? As I handed over the deposition copies to the Land Council for the state. Kete barsha rahileni?
2016.
Acha, the Land Council for the state took some time to obtain to produce the custody certificate number. Ajay ji, you have filed it. handed over the copy of the custody certificate to the Land and Council for the state. Let him verify the same, and the Land Council for the state shall obtain instruction regarding the criminal antecedent, if any, against the petitioner. So also the conduct of the petitioner while in jail. Hello? सेटार वेरीफाई कर दियंतु आउ ये दीटा इंस्ट्रक्शन नै आसन 11 तारिख आसीबो 11/8/2025
Item 25.
आउ की जॉइन कर लगी करना
10th of prisoner petition.
prisoner petition अछि engagement of advocate Chittaranjan Mishra in place of DR Mishra single appellant are there?
Yes.
Wakalatnama filed.
Yes.
Period the prisoner's petitions wherein it is prayer has been made for engagement of Mr. Chittaranjan Mishra as his advocate. Mr. Wakalatnama file करचंदी?
Yes.
Mr. Mishra and his associates have already filed Wakalatnama. The Wakalatnama is accepted. The names of other counsel shall not be reflected in the cause list henceforth. कौन आपनकर बिल आगु रिजेक्ट हिची?
Yes, madam. 5/4/2022.
इबे
5/5 April 2022.
22.
Yes, madam.
22. So have you how many years you are in custody?
14 years.
Or have you got the custody certificate in hand? आपन पार अछि? अच्छा लिखंतु IN number 1668 of 2025. This is an application for bail. The Land Council for the state seeks some time to produce the custody certificate and also to obtain instruction regarding the criminal antecedents, if any, against the petitioner and his conduct in jail. Put up this matter on 11/8/2025.
Now he's in Kuntuni.
लिखी दियंतु आपण खुंटुनी जेल अछि बोली ठीक अछि ऑलराइट आसिलेन को जेल बलांगीर
और बीरण अछि
ठीक है बलांगीर तो अछि आइटम नंबर 3 टा बात
Pass over item number 3.
बलांगीर जेल लोक अछंदी आपण अनम्यूट करंतु
आपण अनम्यूट करंतु
ताले हम आपण जा कहउछन हां आपण सुनी पारछन हम जा कहउछु अच्छा ये कृतिवास मिश्र बोली जणे जे कि एठी अपील दाखल करछंदी सीए आउ अन्य माने बलांगीर रो एडिशनल सेशन जज कोर्ट रे ट्रायल फेस कले 302/307/34 दफारे आउ 26/9/1998 मसीह से कृतिवास मिश्र को 302 दफारे आउ 307 दफारे तांको दोषी साब्यस्त कराई आजीवन कारादंड दियाला से लोक स्टेटस कौन से बुझियाकू कारण ता कि अपियर करना एठी वर्तमान
सर वर्तमान से तो जेल रे नहंती सर
हां
जेल रे से नहंती
जेल नांती माने गले कुआडे ओकालत नामा रे
साइन ହେଇଛି 1998 ମସିହାରେ ସେ ବଲାଙ୍ଗୀର ଜେଲରେ ଥିଲେ କୃତିବାସ ମିଶ୍ର ତାଙ୍କର ଟ୍ରାଏଲ କୋର୍ଟ କଥା ତ ଆମେ କହିଲୁ ଯେ ତାଙ୍କୁ ଆଡିସନାଲ ସେସନ ଜଜ୍ ବଲାଙ୍ଗୀରରେ 302 ଦଫା ଆଉ 307 ଦଫାରେ ତାଙ୍କୁ ଆଜୀବନ କାରାଦଣ୍ଡ ହେଇଛି ଜଜମେଣ୍ଟ ପାସ୍ ହେଇଛି 26/9/1998 ରେ ସେ ଲୋକ ସେତେବେଳେ ବଲାଙ୍ଗୀର ଜେଲରେ ଥିଲା ଯେତେବେଳେ କ୍ରିମିନାଲ ଆପିଲ ଫାଇଲ କଲା ସେ ଦସ୍ତଖତ ମଧ୍ୟ ଓକାଲତନାମାରେ ସେ ବଲାଙ୍ଗୀର ଜେଲରୁ କହିଛି କାରଣ ସିଲ୍ ଇମ୍ପ୍ରେସନ ରହିଛି ବଲାଙ୍ଗୀର ଜେଲର
ରେକର୍ଡ କଣ କହୁଛି
ରେକର୍ଡ କଣ କହୁଛି କୁହନ୍ତୁ ସେ ବିଷୟରେ କୃତିବାସ
ବିଷୟରେ ରେକର୍ଡ ଚେକ୍ କଲେ
ସାର୍ 15/5/99 ସେ ଭବାନୀପାଟଣା ଜେଲକୁ ଟ୍ରାନ୍ସଫର ହେଇଥିଲେ ସାର୍
ଏ କୃତିବାସ ମିଶ୍ର ବାପା ନା କଣ କହିଲେ
ନରସିଂହ ମିଶ୍ର ସାର୍
ଠିକ ହଁ ତା ଘରଟା କୁହନ୍ତୁ
ଭବାନୀପାଟଣା ଟ୍ରାନ୍ସଫର
କମିରା ସାର୍ କମିରା ବିନକା
ଟିକେ ରୁହନ୍ତୁ
ସାର୍
କୃତିବାସ ମିଶ୍ର ହଁ ଭିଲେଜ ଠିକ ଅଛି ସେଇ ଲୋକ କେବେ ଗଲା ସିଏ
ସାର୍ 15/5/19 ସେ ଡିଷ୍ଟ୍ରିକ୍ଟ ଜେଲ ଭବାନୀପାଟଣାକୁ ଟ୍ରାନ୍ସଫର ହେଇଛି ସାର୍
ଭବାନୀପାଟଣା ଏଇଟା ଲେଖି ଦିଅନ୍ତୁ ତାକୁ ଭବାନୀପାଟଣା ବାଲାଙ୍କୁ କହିବେ ଇଏ କରିବା ପାଇଁ ଏ ଯୋଉ ଇଏ
ସାର୍ ପୁଣି ବଲାଙ୍ଗୀର ଜେଲକୁ ସେ ବ୍ୟାକ୍ କରିଛି ସାର୍ ତାର ରେକର୍ଡ ଟିକେ ବୁଝିବାକୁ ଚାହୁଁଛି ସାର୍
କଣ
ପୁଣି ସେ ବଲାଙ୍ଗୀର ଜେଲକୁ ବ୍ୟାକ୍ କରିଛି ଭବାନୀପାଟଣା ଜେଲରୁ ସାର୍
ଅଛି ତ ବଲାଙ୍ଗୀରରେ ବର୍ତ୍ତମାନ କୋଉଠି ଅଛି
ସେ 2010 ରେ ପୁଣି ଜେଲରୁ ବାହାରିଛି ସାର୍
ବାହାରିଛି ମାନେ କଣ ବେଲ୍ ହେଲା ନା କେମିତି ବାହାରିଲା
ବେଲ୍ ନା ପ୍ରିମିୟର ରିଲିଜ ସାର୍ ଡକୁମେଣ୍ଟ ଦେଖିଲେ ଜଣା ପଡିବ ସାର୍
କଣ
ତାର ରେକର୍ଡ ଦେଖିଲେ ଜଣା ପଡିବ ସାର୍ ସେ ପ୍ରିମିୟର ରିଲିଜ ନା ବେଲ୍ ରେ ଯାଇଛି
ସେଇ ଜିନିଷ ଆମେ ଜାଣିବାକୁ ଚାହୁଁଛୁ ପ୍ରିମାଚ୍ୟୁର ରିଲିଜ ହେଇଛି ନା ଆଉ କୌଣସି ଅପିଲ ଫାଇଲ କରି ବେଲରେ ପଳେଇଛି ସେଇ ଜିନିଷ ଜାଣିବାକୁ ଆମେ ଚାହୁଁଛୁ ତେଣୁ ଆମେ ଆକୁ ଶୁକ୍ରବାର ଦିନକୁ ରଖୁଛୁ ହେଲା ଶୁକ୍ରବାର ଦିନ ଏ ମ୍ୟାଟର ଲିଷ୍ଟରେ ଆସିବ ହଁ ତେଣୁ ଠିକ ସେ ବୁଝିକିନି ଆମକୁ କହିବେ ହେଲା ଦୁଇଟା ବେଳେ ମ୍ୟାଟର ଟେକଅପ୍ ହବ ହେଲା ଏଇଟା ଲେଖନ୍ତୁ ଆଇଟମ ନମ୍ବର 3 ରେ ଲେଖନ୍ତୁ
item 3
हाँ 3 पूरा CRFL number 302 of 1998 non appears for the appellants the appellant preferred this criminal appeal in the year 1998 and the wakalatnama was signed from from সেটা আপনাদের কোন ডিস্ট্রিক্ট জেল বলাঙ্গীর না কোন
কোন আপনার ডিস্ট্রিক্ট জেল বলাঙ্গীর না ডিস্ট্রিক্ট জেল বলাঙ্গীর
from district jail Balangir stop we instructed the learning council for the state to ensure the appearance of the concerned jail superintendent to ascertain about the well-being of the appellant Krutivas Mishra. ये जी appear कले अपना ना कौन फोन
आपन ना कोन
अनम्यूट करंतु ना कौन अपन को
सर रोहित भाई सर
कौन
कोन ना कहले
रोहित भाई सर
रोहित भुई आपनकर डेजिग्नेशन कौन
सर वाटर सर
warden Rohit Bhui warden appears through virtual mode and submits that he may be given some time till Friday to ascertain regarding the well-being of the appellant. Stop. The matters will be listed on 1st of August 2025 and it will be taken up at 2 p.m. The concerned jail superintendent shall appear through virtual mode and apprise this court about the status of the appellant Krutivas Mishra. Right? Free copy of the order be handed over to the Learned Council for the state. एटा दुई 1 तारीख दिन 2टा बेलू रहिला आपण ठीक से बुझिकिनी कहिबे हला हाँ यदि प्रीमैच्योर रिलीज हेइथिबो ताले प्रीमैच्योर रिलीज रो डॉक्यूमेंट सरकारी वकील पाखु पठेबे जदि से कोनोसी केस रे आ गोटे अपील फाइल करी बेल जाइथिबो जदि से जहा आस्थिबो से विषय मध्ये जणैबे हला से अपील नंबर और बेल ऑर्डर केबे गला कोन हला सब डिटेल जणैबे यस एटा रहिला ताले हमर 1 तारीख 1/8/2025 14 14 तो 3टा बजे हां 14 जेल लोग किए अछंती
सर नमस्कार सर
आपण कोन
सर
डेजिग्नेट
नमस्कार सर सीनियर सुपरिटेंडेंट
सीनियर
सुपरिटेंडेंट
कोन ना कोन कहले
सर सुजीत कुमार रावल
सुरजीत कुमार राउत राउल
रावल सर
अच्छा ठीक अछि फास्ट हमें आपको पचारुछु जे आइटम नंबर कोटा कोटा कहला ट्रांसफर अच्छा हाँ आइटम नंबर 6 टा देला 6 टा बार को समीर कुमार नायक बोली जने अक्यूज जहा को कि ये पूरी कोर्ट रे से विचार सम्मुखीन होइथिला आ तक आजीवन कारादंड होइथिला वकालत नाम जदि वो साइन करथिला पूरी जेल लु वर्तमान आम पूरी जेल तो ये नेलु जे से पळे आछि कोन हेल्थ ग्राउंड रे ट्रांसफर हेगिनी आपन को जेल को तो तार कौन वर्तमान स्टेटस कौन से अक्यूज रो समीर
सर अक्यूज स्टेटस सर हमर रिकॉर्ड रेट सर जहां एडमिशन रजिस्टर कहूची कन्विक्ट एडमिशन रजिस्टर सर से 11/4/2004 रे तार डेथ हेतिला सर
तार
सर एठी जेल थिला बेले 11/4/2004 रे से सर सुसाइड करके हैंगिंग रे तार डेथ हेतिला जेल
अच्छा वो डेथ हे जाई छी तो तार गोटे रिपोर्ट आपण देई दियंतु हमें केस टा को क्लोज कर हला आज पठेई परिबे तार गोटे व्हाट्सएप रे कि कोन रे ना पर दिन न
हां सर पर दिन कहले सर बेटर होता माटी रिकॉर्ड
पर दिन पठेई दो पर दिन रखुछु 2टा बेल को आपण से जो पठेई दियंतु रेलेवेंट डॉक्यूमेंट्स हला सर आइटम नंबर 6 को लिखंतु CRLA नंबर 3 of 2004 this is a criminal appeal filed by the appellant Samir Kumar Nayak, son of Ekadashi Nayak, village Golo Bai, PS Jonkia, District Khurda, who was who faced trial in the Court of London, Second Additional Session Judge Puri in ST number 2/13 of 2000 for offence punishable under section 304B, 498A, 302 IPC and section 4 of DPR and by judgment and order dated 2010-2003. He was found guilty and sentenced to life imprisonment. The wakalatnama was filed from District Jail Puri. We asked the London Council for the state to ask the concerned jail superintendent of Puri District Jail to appear through virtual mode, and on such instruction we came to know from the Puri Jail District Jail Authority that the appellant Samir Naik was shifted to Circle Jail Chaudhua, and accordingly we instructed the State Council to ensure the appearance of the Superintendent of Circle Jail Chaudhua, Cuttack. Accordingly, Mr. Sri Surjit Kumar Rao, Senior Superintendent Chaudhar Jail, appeared through virtual mode and apprised this court that Samir Kumar Naik has expired in the meantime, and he will file a report before this court through the Learning State Council. Put up this matter on 1st August 2025. The matter will be taken off at 2 p.m. ହେଲା शुक्रवार दिन 2टा बेले निया जीवो आपण से रिपोर्ट टा पठेई देबे and you are also to access virtual mode ହେଲା अच्छा एटा रहला 1/8/2025 रिपोर्ट रहला तापरे आउ गोटा कोटा आइटम नंबर 8 अच्छा 8 नंबर टा बाहर करूं क्रिमिनाल अपील नंबर होची 343 ऑफ 2007 आदिरे मुदाला होची मिलू ओरफ दिवाकर प्रधान जे की फास्ट एडिशनल सेशन जज कटक रे ट्रायल फेस कला 302 दफारे आउ ताकू 24/5/2004 रे ट्रायल कोर्ट आजीवन कारादंड रे दंडित करछंती तो तार स्टेटस कोन कोंदु
नाटा कन्वर्ट
मिलू ओरफ दिवाकर प्रधान बापा ना होची पित्तवास प्रधान गाँ होची सानो गाँ थाना होची नरसिंहपुर जिला होची कटक जजमेंट होची फास्ट एडिशनल सेशन जज कटक आउ डेट होची जजमेंट रो 24/5/2004 आउ आजीवन कारादंड आउ से वकालतनामा मध्य साइन होची सर्कल जेल 14
डाटा सर हमरो ट्रेसेबल होने सर हमें से
एक मैटर को मध्य हमें रखुछु शुक्रवार 2टा बुझी कि नहीं ये है ना यदि केस रो नंबर अन्य विषय जानिबा को चाहुचंदी ताले सरकारी वकीलों को सहित आपण संपर्क करी से विषय रे अवगत ही जहाँ रिपोर्ट दबा कथा देबे हैला item number 8 none appears for the appellant we asked the Learning Council for the state to ensure the appearance of the superintendent of Circle Jail Chaudhar as the appellant preferred the appeal from the said jail. Mr. Surjit Kumar Rao, Senior Superintendent Chaudhar, Circle Jail Chaudhar Cuttack, appears through virtual mode and seeks some time to ascertain and apprise this court about the status of the appellant. Put up this matter on 1st August 2025. The matter will be taken off at 2 p.m. Out of 11 अच्छा अच्छा ये गोटे अपेलेंट ता ना होची पाचुआ ओरफ प्रसन्न कुमार मुदुली तारो घर होची कुंभार साही कपिलेश्वर ओल्ड टाउन लिंगराज थाना खुर्दा जिला भुवनेश्वर तो ताकू ट्रायल फेस कला सी एडहॉक एडिशनल सेशन जज फास्ट ट्रैक कोर्ट नंबर 2 भुवनेश्वर रे 302 दफारे ताकू 29/1/2010 रे 302 दफारे आजीवन कारादंड आदेश हला एवं ता वकालतनामा मध्य से साइन करची स्पेशल जेल भुवनेश्वर किंतु वर्तमान भुवनेश्वर जेल रु झारपड़ा रु आमे खबर पाइलु जे से प्रसन्न कुमार मुदुली ताकू शिफ्ट कराइची सर्कल जेल 14 को तो ता विषय कोन आपण कोंतु
सर एटा भी ठीक टाइम देले सर हमें टेस्ट
ट्रीटमेंट ग्राउंड रे कोन आछि बेली से कहिले आपण भी एटा को भी रखु शुक्रवार दिन हां सेम ऑर्डर होला
এটা হলো 11 নম্বর না? ফার্স্ট অগস্ট 2025 ହେଲା। ଆଉ କୋଉ ଜେଲ ରେ କୁହାହେଇଥିଲା କି ନା ସବୁ ଆସିଗଲେ? କେଉଁଝର କେତେ ନମ୍ବର? 9 ନମ୍ବର କେଉଁଝର ବାଲା ଆସିଲେ କି? ଆଚ୍ଛା କହିଦେବେ ସେ ଇଏଟା ରହିବ ସେଇଦିନ ଏଇ ଯୋଉ ଶୁକ୍ରବାର ଦିନ ସେ ଆପିୟର କରିବେ। ଏଇଟା ହଉଛି ଆଇଟମ ନମ୍ବର 9 ଟାକୁ ରଖିଦିଅନ୍ତୁ 1 ଅଗଷ୍ଟ 2025 କୁ ହେଲା ନନ୍ ଆପିୟର୍ସ କରିଦେବେ ଆଗେ ଆଉ ସେ ସୁପରିଟେଣ୍ଡେଣ୍ଟ ଅଫ କେଉଁଝର ଜେଲ shall appear to the virtual mode and apprise this court about the present status of the appellant ହେଲା ଏତିକି କରି ଛାଡ଼ିଦେବେ। ଏଇଟା ହଉଛି 1 ଅଗଷ୍ଟ 2025 2 PM ହେଲା କପି ଗୁଡାକ ତମେ ଦେଇଦେବେ ଆଉ ବାକି ଯାହା ରହିଲା ଶୁକ୍ରବାର ଦିନ ଆସିବେ।
I had made a mention of item 41 with regards to the interim bail of the appellant. Have been served with a copy by the informal counsel today. Since the matter is fixed to, well, the wedding is fixed to first, may I pray take instruction if it can be listed in the first hour?
बाकी जहाँ रहिला फास्ट रहिला
Well, it's first hour because the marriage is on first. If it can be taken up as the first item on Friday because the lordship is not sitting tomorrow.
Affidavits. I have served a copy. They have also filed a affidavit. I have just now received.
I have also just now
Affidavit
received
my
a copy
order,
that I would like to
fine.
take instruction.
Let
So since the marriage is fixed on Friday, I am praying if it can be taken up in the first
बाकी
half.
ସବୁ ତକ ମ୍ୟାଟର ପୁରା ଆସିବ ଶୁକ୍ରବାର ଦିନ।
Since it is on Friday, first half, if your lordship will take it as the first item,
this
you
is
will
the
be
second.
able to attend it.
କଣ ହେଲା ବାହାଘର କଥା କଣ ହେଲା କୁହନ୍ତୁ?
Marriage is that is true, but your lordship directed me to obtain the criminal antecedent of the petitioner, conduct of the petitioner.
I find the affidavit.
During interim bail, he is involved in this case, my lord. That apart, in the present case, on the date of conviction, he absconded. No, my lord. Issued NPW during the that I will submit, my lords, from the record itself.
Mr. Kanungo, what do you?
My lords, I had a sub-item under 40, sub-item 2. Lords, the man has been roped in just because he is the brother of the beneficiary.
No, we are bringing all these matters on Friday, right?
May I first hour if you are not.
देखिए
Obliged.